Hi, everyone. Welcome to our training. The title of our morning together is Understanding CWS and the Juvenile Dependency Process, Helping Our Families Heal. We're so glad you're here today. We have a morning of amazing presenters, and we hope that you'll enjoy your time with us. So let me just quickly introduce myself. I'm Babby Weingarten. I'm the Behavioral Health Program Coordinator and one of 3 staff psychologists at Child Welfare. We have 2 other staff psychologists with us just for a few moments this morning that I would like to introduce. We have Dr. Karen Sommerfeld-Forge and Dr. Christine Maggio. So if you're ever wanting to get a hold of one of us, we are here, and I will make those emails available to you. So let's do a quick poll just to see who is here. If you would quickly complete the poll, it allows us to know who our audience is. Okay, so we have term therapists, CWS affiliated, BHS, Optum, legal counsel, court affiliated. I know our CASA will be here later, and one other. So, all right. Let's do poll 2. Just quickly. Okay. So we've got some people who, wow, over 10 years. Thank you. I'm so glad you're here. 7 to 10 years, 4 to 6 years, and a few who are 0 to 3 years. That's awesome. Thank you. That gives us a really good sense of who's here. So I appreciate that. All right. So let's quickly go over our objectives and our schedule, and then I'll introduce our first speaker and we'll get going. All right, so the objectives today. At the end of this training, the participant will be able to understand the juvenile court expectations of term therapists, identify the components of juvenile court legal proceedings, understand the role of the social worker in child welfare agency juvenile dependency process, understand the role of the term therapist in the CWS juvenile dependency process, be able to provide appropriate documentation, term therapists for juvenile dependency cases, and be able to describe the clinical framework necessary when working with child welfare families. This is our schedule, and you'll notice that there's a break around 10:15. If there's time at the end of each talk, we can take some questions, or we can just save them to the end. We've left about 15 minutes for a question and answer section. Okay, all right. So I'd like to introduce Yael Koenig, who is the Deputy Director of the Behavioral Health Services, and she oversees the Children, Youth, and Families Unit. So thank you, Yael, for being here, and I will hand it over to you.
Good morning, everybody, and thank you, Babby. It's really nice to be here this morning with all of you. You probably noticed from the opening slide and schedule that today's training will offer input from various partners. And the County Behavioral Health Services, or BHS, is one of those partners. BHS, like Child Welfare Services, or CWS, is a department under the umbrella of Health and Human Services Agency, or HHSA. We love our acronyms, right? BHS treatment providers mainly fall under three main categories. The first one is our org provider system, or our organizational provider system. This is something that you will recognize as kind of a full service program. These are often contract that community-based organization holds. So for example, you might be familiar with Crossroads under Community Research Foundation, or Tides under the YMCA. These are our organizational providers, and where the majority of the kids who receive behavioral health services from the County of San Diego receive their services. Then we have our fee-for-service network. This is a network that is made up of individual practitioners that serve Medi-Cal beneficiaries on behalf of the county. And they work with Optum to be able to administer those services. And then we have the the third part of our system, which is our term panel. These are clinicians that really provide specialty services to youth, and families are involved with the dependency or delinquency system. So those are just kind of the main three systems that the county oversees. And then the County Children, Youth, and Families Unit under Behavioral Health Services roughly manages about 100 contracts that provide these services. We focus on serving kids that have Medi-Cal or those that are unfunded or have no insurance. Every year, we provide mental health services to over 14,000 kids. About 8% of them, or 1,000 kids, are also involved with probation, and about 13% of them, or just under 2,000 kids, are also involved with the child welfare system. So clearly, partnership is critical. Okay, so that brings us to the slide that you see that really highlights how we are collectively part of a coordinated system of care. Whatever brings you here today, you are part of a system. The slide really calls out our 10 primary principles that guide our system. As you look them over, it's very likely that they resonate for you. So whatever angle you come from, you are probably striving to be trauma informed in the services you offer and the supports that you provide. You are ensuring that you're culturally competent. You want to make sure that the services you offer are youth guided and family driven, and so on. So TERM, which stands for Treatment and Evaluation Resource Management Team, is a unique part of the system. It is a BHS panel that is managed by Optum to serve children in the dependency or delinquency system, as you very likely know. Optum provides the independent oversight of the mental health services. This oversight is a Board of Supervisor requirement to ensure high quality service to a vulnerable population. So we are mandated to have this type of oversight. Through a term panel clinician, kids and family receive psychological evaluation and or behavioral health treatment. And the mission is to provide flexible services that meet and build upon the unique needs, strengths, and potential of each youth and family. Today's speakers are leaders in their respective organization. They will share with us what they are seeking when they request term involvement and how that information is utilized. If you are here today as a term provider or representing another part of the larger system, we acknowledge your role and recognize that we all have a part in caring for the youth in our community. With that, please allow me to introduce the Honorable Judge Espana, who will speak to the juvenile court expectations. Thank you.
All right, thank you, Yale. Good morning, everybody. You know, I'm just looking on the screen here and there's just a chuckle. Like a year ago, I don't think we would all know how to do this, right? With the PowerPoint, seeing all your smiling faces this early morning, taking a survey. Babby, I had no idea we could even do that. Wow, just come a long way with this technology. But I'm also very, very thankful that the light is getting brighter at the end of this COVID tunnel. And hoping that we'll be able to see each other in person at some point in the not too distant future.
Soon.
Again, good morning and welcome. Just a little bit too by way of my background. As an attorney, I started working in the juvenile court in 1983. So for most of my career as an attorney and now as a judge, my family here is at the juvenile court. I was around way back in the day when term was being created, and I remember those days. We needed good, skilled therapists and evaluators to work with our children, youth, and families back then as we do now. So thank you all for being here this morning. Next slide, please. So I'm going to give just a very broad overview for just a few moments. You'll be getting more details as the morning goes on. But the goals of the dependency proceeding is to preserve the family and provide for the safety, protection, and physical and emotional well-being of the child. Preserve the family. Reunification is the goal. And while we're doing that, provide for the safety, protection, and physical and emotional well-being of the child. Next slide, please. So parents have a certain amount of time in which to reunify with their child or children. In most cases, child welfare services must come up with an individualized case plan and provide reasonable services to support reunification. If parents are denied reunification services, and there's a small group for which that happens, or parents fail to comply with their case plan, the next decision for all of us is permanency. So generally speaking, when we take a parent's kids, we're supposed to give them back, but only if it's safe, and then there's a limited amount of time. If we can't give them back, then we need a good plan B. The plan B is, among other things, adoption, guardianship, another permanent plan with a relative, or placement in foster care with a plan of return to a parent, or another permanent plan like adoption or guardianship. Adoption, of course, is the preferred plan B. Right, next. So what does this mean for you? Through your work with children, youth, and families, we need your help determining whether a parent can safely be reunified with a child. So what is the parent's progress in therapy? Is the parent attending, not attending, always late, engaged, participating? Does the parent understand protective issues? If not, does the parent have other protective? What are the challenges facing that parent? What are the positives that that parent presents? We also need your help determining how to help a child deal with their abuse and neglect. Help us understand how trauma has affected the youth. How is the child doing in therapy? What is it that we can do to help the child or young person heal? Again, what are his or her challenges? What are the positives? We need your help figuring out the best permanent plan if it's not going to be the parent. So overall, how is the child or youth doing? How is the child doing in his or her placement? What are the child's needs? What services could the child benefit from? Your opinion is very important to us. It helps us make the best decision possible for the parent and the child. Next slide, please. So what are the common issues that you see? The role of trauma. We believe as a system that we are getting better understanding, or we're understanding better the role of trauma and its impact on a person's behavior. But we all need to be reminded and especially understand the role trauma has had on the parent or the child that you're working with. The impact of in utero drug or alcohol exposure, another common issue you will see, and help us understand the impact that that may have on a child or youth's behavior or challenges, the effect of developmental delay, the power of addiction, which affects so many of the families that come before the court, and the challenges of mental health as well. These issues I have been working with when I first came to the court in 1983. So long-standing issues and continue to be issues that impact our children, youth, and families even today. The work for our foster teens can be particularly challenging. So we definitely need your help with that population of youth too. How can we help them calm? How can we help them heal? Next slide, please. So you may be asked to do a psychological evaluation of a parent or a child. We read these, we copy them out, we highlight them, we make notes on them, on our own notes with regard to the psychological evaluations. They're important. So when preparing these reports, please explain the diagnosis and why you come to that conclusion, what the treatment plan should be, why you're recommending a particular type of treatment or therapy. What does a therapy label mean? If you use an actuarial tool, what does it measure? And what doesn't it measure? I also want to know what information you received for the evaluation and from what source. Next slide, please. Oops. Oh, there you go. Thank you. Treatment reports. We get those often. Those are also so critically important. What we want to know from them is, how is the client participating in therapy? Again, is the client coming, attending, always late, not coming, participating, engaging, or not? I mean, we need to know that. That helps us. That's one piece of information that we need in order to make the best decision possible for our families. What's the client's current functioning? What are the goals for therapy? What's the parent or child's progress in therapy? What additional service needs? How best can we help the child, the youth, or the parent? We want your ideas. Remember, you are speaking through your reports to the social worker, the attorneys, parents likely read these, also likely older youth, CASAs, and of course the judge. Include in your reports what more, if anything, you believe can help serve your client. All right, next slide. Again, thank you so much for all you do. And at any time, really, as part of your work with our youth and families, I am here, I am available to answer questions, not family specific or child specific, but if you just want to reach out and say hello, I'd love to hear from you. So again, thank you very much. And I'm hoping that you have a wonderful training this morning. Thank you.
Thank you so much, Judge Espana. Does anyone have questions at this point? We have a couple minutes. I see Caitlin is here, so that's great. Anybody have questions or thoughts? Okay. Thank you, Judge Espana. All right, so Caitlin. Caitlin Ray is our Chief Deputy County Counsel for the Juvenile Dependency Division. After obtaining her JD and Master's in Social Work, she joined our office in 2003. And over the last 18 years, Ms. Ray has appeared in every court, handled specialty calendars, defended social workers in civil suits, and initiated the embedded county council positions in regions. Thank you so much, Caitlin, and I will hand it over to you.
Good morning, everyone. And Babby, I'm going to, I came in a little bit late to Judge Espana's presentation, so should I just ask when the next slide should go?
Yes, you just tell me when you want the next slide to go.
You're doing it. Okay, great. Good morning, everyone. I'm here to discuss a very quick, down and dirty overview of the juvenile dependency legal process. It is going to be way too much information to really contain in 45 minutes, but I'm going to do my best just to go through kind of the timeline, the big hearings that are in the juvenile dependency process. I believe there's also in the handouts a flow chart, which is really, really helpful and is a visual to show how referrals move on to cases, and cases move throughout the court process. So we will go to the next slide. So just, you know, you hear it all the time through either the different partners or through the system or even through the County of San Diego, through their Live Well program or their mission and vision. But for the purpose of the dependency system is really three important things. First, to protect children is always the first and foremost idea in everyone's mind. Second is to preserve families. It seems maybe sometimes the dependency system or the agency might get a bad rap because they're known to break up families or separate children, but really the purpose and the goal is to preserve families. And then within that is to provide children with safe, stable, and permanent homes, whatever that might be. Obviously, their home of origin is the preference, but if children are removed and parents are unable to reunify, we want to provide children with safe, stable, and permanent homes for the rest of their lives. So the next slide. And as maybe Judge Espani has noted, she's the presiding judge of the juvenile court, but this is just a rundown as to the different players that you might see in the court process. Obviously the court, the judge handling the case in that particular department, obviously the child, the parents, the agencies as they've known, is known collectively as the agency, and then the individual social worker who might be handling that particular case. We have things called de facto parents. So de facto parents might be caregivers who are caring for a child who have elevated their status with the court to become a party. So the only way a caregiver or someone who is caring for a child can become a party to the action is if they qualify under the de facto parent status. And then the rest of us, the attorneys, parents counsel, minors counsel, county counsel on behalf of the agency, CASAs. We have relatives, they might be relative caregivers or just relatives of the child. And then an acronym, which is NEFRMs, non-related extended family members. These might be caregivers who care for the child who are not directly related to the child, but are a family friend, a teacher, a support, someone that the family knows who takes on the care of the child. Service providers like yourselves in all different fashions. So those are some of the names of the types of people you would see in the process itself. And we can go to the next one. So this is a loaded slide, and this is kind of the timeline and also the order of hearings that we're going to go through over the next few minutes in terms of the process itself. As we move through this, we're going to break this up into phases. And starting with the removal or the filing of the petition, we're actually going to start ahead of that a little bit, all the way through the initial hearing, through the jurisdiction hearing, the disposition hearing, which is an important hearing, and then through the reunification timeline, 6, 12, 18, and 24-month review hearings. And then the permanency hearing 366.26. Sometimes you'll hear that called the 2.6 hearing or the permanency hearing, and then the post-permanency review hearings, which occur after a permanent plan has been established. So again, that's also on your flow chart, but that's just in bullet point visual fashion. Oh, thanks, Fabi. We can go on to the next one. So I'm going to spend a little time here because I think this is important for context in terms of what you might be seeing as a service provider, as a therapist in our cases. So I call this phase 1. This is like the investigation phase. And also just to give some context on that flow chart, the way child welfare services becomes known to a child or to a family is because there's been a report to the hotline. So the report to the hotline can be from a mandatory reporter, it can be from a neighbor, it can be anonymous, it can be anyone who says or believes that a child has been abused or neglected or is at risk of abuse or neglect. Once that report hits the hotline, it is filtered to determine whether an investigation should begin on that child and family. And to give some context, so some pre-pandemic numbers, because well, the pandemic has just upended everything, so I don't want to use that as a baseline. But prior to the pandemic, the CWS, the County of San Diego, received about 40,000 calls to the hotline every year, about 40,000 calls or reports to the hotline. That would generally generate about 22,000 investigations. Not every report is investigated, because you can imagine someone makes a report and it's about a child who doesn't even live in the jurisdiction of the County of San Diego. So someone might call in and say, I'm worried about my grandchild, and they live in Minnesota or something like that. So that's not going to generate an investigation here. So as they get filtered down, it's about 22,000 investigations. My recollection is that those 40,000 hotline calls encompass about 89 to 90,000 children. And then we're brought down to 22,000 investigations performed by our CWS social workers every year. And there are time frames for those investigations. That investigation normally has to be completed within 30 days. So most of them, some of them take longer than 30 days, but the objective is to complete the investigation in 30 days. The important part of that investigation, the purpose of that investigation, is to determine whether the child has been abused or neglected. And social workers use their investigative techniques to make that determination. Within that determination, they're also making a determination whether the abuse or neglect has occurred or is occurring, and also, is that child at risk of future abuse or neglect? So the investigation in some ways is looking at the current circumstances and maybe the allegations as to what has occurred, and then also future looking into, if it has occurred, is that child continuing to be at risk of abuse or neglect? Is that child in a situation where something needs to occur to remove them from that situation or put supports in place to protect that child? The first and foremost idea in the investigation, besides determining whether abuse or neglect has occurred, is also to determine the child's safety at all times from the first moment. So once the investigation over the course of 30 days has gone through its process, and the social workers have very strict guidelines as to how they conduct their investigations, what they can and cannot do, who they talk to, they try to gather as much information as possible, making contact with the family and the children, any collaterals. Once they've determined that abuse or neglect has occurred, then they have a variety of tools in their toolkit to determine what should the agency do with this family. What should their intervention be? Should resources be offered to the family and they close the referral and let them on their way? Should they engage with the family in a voluntary case plan, meaning that the child is at risk of entering foster care, but the family is willing to engage and work with the agency on a voluntary services plan to avoid foster care, to avoid the dependency process? Should the child be removed at any point in that investigation if the child is unsafe, either in the moment or long term? Should there be a situation that the child needs to be removed? If a child is removed, that usually, not always, initiates the court process. So once a child is removed, the agency has 48 hours to file a petition or return the child to its family origin if that child had been removed without a court order or consent. And then finally, if the child is removed, or if the child hasn't even been removed, but court intervention is necessary. So does the child fall under section 300 A through J? Meaning, is the child described under the jurisdiction of the court that the family needs to be brought into the jurisdiction of the juvenile court to provide protection, safety, and long-term either reunification or some sort of rehabilitation to ensure that the child remains safe, that the family can either reunify or a permanent plan be established. So this phase is really, really important because it sets the family in one 2 or 3 or 4 different directions. Maybe a family receives a referral and the referral is never acted upon, meaning it's investigated but closed and there is no intervention. So sometimes you hear that as child welfare history, that families had had list of referrals and investigations, but not any formal intervention. Or you hear interventions such as voluntary case plans or referrals for different resources. Maybe it's housing or some other resource the family might need, or there is a prior dependency case, or it leads to a dependency case. So once we've talked about 40,000 hotline reports per year, essentially, the pandemic, like I said, it's kind of upended that. 22,000 investigations, and drawing that down, we're currently at about, someone's going to have the exact number, but I'm just going to put it at about 2,200 foster youth in our system. So drilling that down, what you see are as a service provider in the dependency system are the filed cases. So 2,200 foster youth from ages infant 0 to 21. And our cases on average last, I would say 12, 15, maybe 18 months, depending on how a family progresses through the system. So you're really seeing, if you want to think of the iceberg, like the tip of the iceberg, because a lot of the child welfare work and a lot of the work that CWS does never comes to court. And in voluntary cases, I believe, and my numbers might be skewed, at any given time, there might be maybe 1,000 voluntary cases going on. It's hard to say. The voluntary cases are time specific and mostly limited to 6 months. So unless you pull out like a point in time, it's hard to say exactly how many voluntary cases we have, but maybe 1,000. And if I do some research, I'll put that back in the chat as to find the exact number. So when we're thinking about the dependency process, the decision to engage in the dependency process from the CWS standpoint is a really crucial decision. And really that crucial decision is, one, you bring a court system involved, you have attorneys, judges. It's traumatic in and of itself to be part of this process for families and children. And then secondly, the ultimate consequence, which we're going to get to, the ultimate consequence in the juvenile dependency process and filing these petitions is the possible termination of parental rights. And for all parents, that is the ultimate consequence, that they could be permanently severed from their child, that they wouldn't have physical contact, they wouldn't be their legal parent. So these decision points are crucial, and the system is set up on this spectrum to ensure that at every crucial moment in the dependency process, that we have thoughtful recommendations, we have a neutral decider, because at the end of the process, it could be that parental rights would be terminated. So again, that's why phase 1 is really important, because we want to really ensure that the right families get the right resources and the right intervention, so that if that requires juvenile court jurisdiction, that the right families are in there. If it's a voluntary case plan, that the right families are the ones that can engage in a voluntary case plan and avoid juvenile court, but have that need for some sort of service intervention. So we can move on to phase 2. And just as the bullet point, phase 2 is the initial phase of the actual juvenile court dependency process. These hearings, the detention hearing, jurisdiction, and disposition hearing, are the 3 main hearings. And I think it's important, as service providers coming on and learning about this process and then being part of this process, those are the hearing names: detention hearing, jurisdiction, disposition hearing. And like all hearings, depending on what's happening on a given day, we can have multiple detention hearings and multiple jurisdiction hearings. Sometimes these hearings are continued. So they have the initial hearing. If for some reason anything as much as a parent wasn't able to attend the hearing, child wasn't able to attend the hearing, an attorney was out sick that day, or we need to do some more investigation or more work on the outside before we can move forward in that hearing, a jurisdiction hearing may be continued, or a detention hearing may be continued, or a disposition hearing may be continued. So you might feel like, I really think we've been through jurisdiction on this case, and it feels like it's never ending because you might have multiple jurisdiction hearings until finally the court and all parties are ready to make the ultimate decision as to what should happen about jurisdiction. So just want to remind folks of that there might be multiple hearings with the same name. It's just because it hasn't been completed. Those findings and orders that are required for that hearing has not been completed. So let's start on the next slide. And let's start with the detention hearing. These are the main things that court and parties are discussing and looking at a detention hearing. The detention hearing is the initial hearing. Sometimes detention hearing leads everyone to believe that the child has been detained in some way or is out of the custody of the parent. And that's not necessarily true. If a child is still within the family home with a parent, the child has not been detained, but it would be the initial hearing, bringing that family into the juvenile court process. Our detention hearings, the way they work in the County of San Diego is that they occur within 24 hours of the filing of the petition. So just practically speaking, we file petitions every day, almost every day, Monday through Friday. And so if a petition is filed on Monday, which is done through the business office at the juvenile court, the detention hearing is set for the next morning at 8:30 a.m. Detention hearings are set at 8:30 across the county in the 5 courtrooms. And it's within 24 hours of filing the petition. At that hearing, we have attorneys who are appointed. County counsel is on every single hearing. We're not appointed. We automatically represent the agency on these cases. And then the attorneys are appointed at the detention hearing. So at every detention hearing, CLS, Children's Legal Services, who you'll hear from, is appointed on behalf of the child or children. And then attorneys are appointed for the parents. It may be that attorneys are appointed throughout the life of the case for the parents, because mostly they are appointed for parents who appear in court. So right now our hearings are virtual, so they have to appear or make contact for the attorneys to be appointed, or if they're in custody most of the time, then parents counsel will be appointed as well. So the attorneys are appointed, they're given an opportunity to discuss the allegations of the petitions with their clients. When we are in person, the petition is formally given to the parents, served on the parents. The attorneys go through those allegations with the parents, and I'll let DLS, when they come on, talk about what their role is. But the crucial questions at the initial detention hearing are these pieces next. Should the child be with the parents or out of the home? So if the child had been removed prior to the detention hearing, whether that was by a social worker or by law enforcement, whether that was with a protective custody order, or whether it was out in the community without any order, the first question is, should that child remain at a home, or should that child be returned to the parents? Or even if the child is currently with the parents, there could be a request, or there could be an issue about whether that child should be removed from the parents. So the initial question is, where's the child, and where's the child going to remain pending this process? If the child is not with the parents, is there a placement with a relative that is readily available? Should the child go with a relative temporarily as we figure out this process? What should the visitation order look like if parents are not with their children? Supervised visits, unsupervised visits are the general orders. And then what voluntary services should be provided. So at the detention hearing, the court has limited jurisdiction over that family so far. So services at that point are referrals or resources offered to the parents and to the children. And for the parents specifically, if they want to engage in those services, they can. They're voluntary at that point. It is not until we get later on in the process where services are ordered. So during the voluntary voluntary piece, as we figure out jurisdiction, parents engage in services sometimes, and sometimes they don't. And then temporary orders are made. So that might be temporary orders involving education or other issues, visitation, maybe temporary orders about passes for relatives or some other logistical or matter that's affecting the child. So that detention hearing is within 24 hours of filing the petition. That is a lot going on in that first hearing. And then from the detention hearing, Babby, we can move on to the next one. The court will set a jurisdiction hearing, and at that detention hearing, the court will say the next hearing will be the jurisdiction hearing. And at that hearing, the court will decide whether the allegations of the petition are true and whether this family is appropriate to come under the jurisdiction of the juvenile court. This is a crucial moment because if the petition is what's called dismissed, meaning the allegations are not true, then everyone closes up shop and the family goes on its way. Or the court sustains the petition and now we move through the dependency process. This jurisdiction hearing is initially set 15 days from the detention hearing. So if our detention hearing is on a Tuesday, normally the jurisdiction hearing will be 2 Tuesdays from then, or maybe 2 Tuesdays in a day on 3 weeks later, 15 days. That 15 days is not a lot of time, although in the light of a child, or the eyes of a child, or the eyes of the parents, it seems like forever. On the child welfare side, a lot has to occur during those 15 days to be prepared for the jurisdiction hearing. And so during that time, that's when those temporary orders are in place. Maybe that the child is detained, or relatives are being assessed for placement, or the supervised visits are occurring, or unsupervised visits are occurring. So at that hearing, at the jurisdiction hearing, the court determines if the allegations of abuse or neglect that are filed under 300 subsections A through J, whether those allegations are true. And in order to find those allegations to be true, the court has to find them under a standard of review that's called preponderance of the evidence. So the court has to find that it's more likely than not that those allegations are true. The easiest way to think of it is if it's a scale, 0 to 100, preponderance is like sometimes qualified as 51%. That 51% of the evidence establishes that the allegations are true. If you watch the news or you read, mysteries or whatever else, or crime novels, in the criminal arena, in the criminal courts, the standard of review is what you've seen or heard beyond a reasonable doubt. Beyond a reasonable doubt is more like 99% true. So in the jurisdiction hearing in the juvenile dependency process, when a court makes a true finding, it makes it, most of the time, makes it by preponderance of the evidence. We're going to get to another standard review later that's called clear and convincing evidence. Clear and convincing evidence is equivalent to about 75% if you're thinking on a scale of 0 to 100. So the court is tasked with finding, based on the evidence presented before it, whether there's preponderance of the evidence that the allegations in the petition are true. The parents and the child both have the ability to contest the petition. So that's when we say, or you hear, it's set for trial. So the parents will say at the first hearing, we need to set this for trial because we don't believe the allegations to be true. Which then sets a further date, and maybe another further date and another further date as the parties prepare for a contested hearing. Parents and children have the ability to contest the petitions. They have the ability to bring witnesses. The agency can bring witnesses. Those witnesses can be live witnesses. They can be documents. All the rules of evidence and then our dependency rules of evidence apply in the contested matters, the contested jurisdiction hearings, and any other contested hearing. So sometimes it takes a while to get through jurisdiction because some of these contested hearings either are delayed, it takes time to gather all the evidence, to get all your witnesses straight. Also, almost all of these are set on the contested calendar. So the contested calendar is usually in the afternoons or all day on Fridays. And as we have these cases flowing into juvenile court, the calendars become backlogged. And so the contested date might not be for another 4 or 6 weeks out. Contested jurisdiction hearings can last anywhere from a few minutes by the time it's all said and done to multiple days. In my experience, the longest contested jurisdiction hearing I had was 13 days, which is really long for dependency over the course of about 6 weeks. But we've had other contested hearings that lasted months because they would not finish each day, then have to find another day. So that's kind of the anomaly, but normally once they're started, they can get done in relatively short time, maybe a few days. We can move to the next one. So this is, for your purposes, important as the service providers as to what the significance of the true finding. So the agency makes allegations and writes them on the blue petition to say that the child comes under section 300, whatever it is, A, B, C, D, I, J, whatever the subsection is. And then through the course of a trial or through negotiation, sometimes that language is tweaked and changed, sometimes it isn't. But then when the court comes and makes the true finding, the court is finding that whatever is written in that petition, even if it's been amended, whatever the amendments are, that the allegations of abuse and or neglect, whatever they are true. And that becomes the guiding post for the rest of the case and to the basis as to why the juvenile court is involved. That guiding post often sets the case on a trajectory as to what services should be provided or offered to this family to help them. What services are tailored to the reasons why we're involved in this family. Is it substance abuse, physical abuse, mental health problems, whatever that might be? And as that guiding post, those services are intended to ameliorate the condition that led to the juvenile court's intervention or their true finding. So as service providers, once that true finding has been made, it's not the responsibility of the service providers to question the veracity of that true finding. I know as we talk further throughout the day, sometimes there's issues around that because even though a court has made a true finding that, let's say, just very hypothetically, a parent physically abused their child, that parent might be your client and that parent will still come into therapy and say, I didn't do it. And so that is an issue that needs to be worked through, obviously. So the parent might disbelieve that actually is true, but the court and the parties and everyone in the dependency process is under the guise that that true finding has been made, that that parent conducted that action and abused that child. That said, up until that jurisdiction hearing, it is still just an allegation of abuse or neglect. So during that period of working with a client prior to jurisdiction, it's a little bit different than once the court has come in and said, yes, there is a true finding on this, or I'm making a true finding on this, to then set the rest of the case in motion as to what services should be provided, how the services should be provided, what should be the goals and treatment as such. Okay, we can move to the next one. The disposition hearing. So the disposition hearing, if the jurisdiction hearing is to determine whether the court should be involved in this family, that's the first question, yes or no, by preponderance of the evidence. The second question is, okay, then what happens next? What happens with this family? Should they be offered reunification services? Should the child remain in the parent's care or out of the parent's care? Should we bypass all of that and move to permanency depending on the facts of the case? But the disposition hearing is the formal intervention, and the disposition hearing has a lot of components to it. Technically, the jurisdiction and disposition hearings, that first time it's set, is set together. Jurisdiction hearing and disposition hearing is set 15 days from the detention hearing. However, as we see, they get continued, they get set for trial. And so oftentimes they are either bifurcated, meaning the hearings happen separately, or as time goes on, finally the jurisdiction hearing is accomplished and then the disposition soon after follows, maybe in the same day or maybe set out a little bit. So it often occurs on the same day as the jurisdiction hearing. We have a mandate that the disposition hearing has to occur within 60 days of the child being initially removed and no longer than 6 months. The purpose for that mandate is that we need to move these cases because as these things are, as evidence is being gathered, witnesses are subpoenaed, the child is growing and progressing on through life. And because of that, the statutory framework is such that we can't just languish and take too long to get to this ultimate question as to what should happen with this family. So if a disposition hearing takes longer than 60 days, the court has to make an actual finding as to why, what's the good cause to go past 60 days to determine what should happen for the rest of this case. So the important things that are happening at a disposition hearing really sets the tone for the rest of the juvenile dependency case. First, whereas the court has found jurisdiction, the dispositional finding, the important one, is whether or not the child is going to be declared a dependent of the juvenile court. In delinquency world, it's called a ward. In dependency world, it's called a dependent. So the child declares the child a dependent. The child can be a dependent whether or not they're with the family or with outside the custody of the parents. So the court declares dependency. Now they have become involved, and now we're going to set the rest of the tone. The second question, really maybe the important question for the family and especially the parents, is will this child formally be removed from the care, custody, and control of the parents? So even though the child might have been temporarily removed up until this time, maybe detained is sometimes the words that you hear, or the child is in a foster home or in a relative's home or at Polinsky or in a group home. The question is, has the child been formally removed? So to remove custody from a parent requires the higher burden, the higher standard of review of clear and convincing evidence. So to formally remove custody means that the court has to find by clear and convincing evidence that it would be detrimental for the child to remain in the parent's custody. And so for that purpose, that then sets on the track of reunification. So if the child is removed formally from the parent's care, custody, and control, then they enter into something called FR, family reunification. However, if they're not removed and the child remains with the parents or parent, they might be in what's called family maintenance, that there's been no formal removal order. Removing a child sets the time clock. So the statutes have set out that there's only a certain amount of time that a child has to reunify with their parents. And that time clock is set from the moment that the child is formally removed from the care, custody, and control. And then if the child is removed, what should the actual placement be? The child might have been detained before, maybe it was with a relative or in a resource home or in a group home, but what should the placement level be? Is the placement level licensed foster home, which would include a resource home, a relative, or is it a relative, or is it a nephrom, that family friend, or is it a group home? So what is the placement level to make that decision as to where the child should be formally placed, even though maybe physically the child has been somewhere for some time? And then the next question that is determined at the disposition hearing is whether or not reunification services should be ordered or denied. The presumption is if a child is removed from the care, custody, and control from the parents, reunification services shall be ordered. The presumption is parents will receive reunification services in their attempts to reunify. But there are, I don't think it's up to 16, 17 bases to deny parents reunification services. And this is an important hearing because, for example, if parents had gone through reunification services in the past with other children, and fail to reunify, the legislature has said, well, you don't necessarily then get reunification services again. So the agency can make a recommendation to deny services on the 4th, 5th, 6th, 7th child, and then go through a trial and go through the elements of what's involved in that disposition to either order reunification services or deny reunification services and go straight to permanency. So this disposition hearing really sets the tone. Are we on the track of family reunification? Are we in family maintenance, or are we going straight to permanency? And concurrent planning, for some of you, I think I saw the poll that some of you have been doing dependency work for some time, might be a relic of like the old days. But I still think concurrent planning is around, and concurrent planning is really just planning for permanency for a child. If a child is in family reunification, the concurrent planning is having 2 different plans. Plan A is always reunification with the family, right? Get that child back to the family of origin with their parents. Plan B is the concurrent planning piece. If that were not to occur, that failed to happen, are we making efforts that we have another permanent plan ready to go, whether that's with a relative or in the licensed foster home or resource home? What's that permanent plan going to look like should reunification fail? Because what we don't want is we don't want to go through all this reunification and then start saying, hey, I wonder what we should do with this kiddo or kiddos, and have them languish on and on in a permanency plan that's not as permanent as it can be. So we can go on to our next phase. So hitting into our next phase would be reunification. So once jurisdiction has been established, once disposition has been established as to the track this case will take, we're going to talk briefly about these 6, 12, 18, and 24-month review hearings. And then just basically that parents, the idea generally is that parents have 12 months to reunify. That's the goal, 12 months to reunify, except parents are only entitled to 6 months of services if their child is under the age of 3 or in a sibling group where they're all placed together. So that means entitled to 6 months of services means that they can get more if they're doing what they're supposed to be doing, but the 6-month review becomes crucial for those kiddos. But generally, parents are entitled to 12 months of services, and they can get more, and we'll talk about how that goes. 12 months of services for all the other types of kiddos. We can move on. We'll talk about the specific hearings. So at all review hearings, these are really the main issues that we're going to talk that the court will be reviewing depending on where we are. So the 6-month review is set 6 months from the date the child has entered foster care. And so sometimes it seems like the 6-month review is 1 month and the 12-month review is the next month. And there's some wonky calculations that occur in dependency cases for that to happen. But if that happens, that's because there was a delay getting to jurisdiction and disposition in the first place. But at the 6-month review, the first and foremost question is, can that child be returned to the parents? If the child has not been returned to the parents during that first 6 months, can the child be returned to the parents? Is it detrimental to return the child to the parents' care? And you'll hear throughout some of the other lingo is that throughout the course of reunification, a social worker might have discretion to lift supervision, to go to unsupervised visits, to start overnights, short-term overnight visits with parents, or to start a 60-day trial visit during the course of reunification. At that 6-month mark, if the child is not already with the family, with the parents, maybe a 60-day trial visit has begun, or maybe if it hasn't, the child is not with the parents, the question legally is, can the child be safely returned to the parents? The next question is, during that 6-month period or 12-month period, whatever review period we're at, has reasonable services been offered or provided to the parents? So we know down the line that if parents fail in their reunification efforts at the permanency hearing, parental rights can be terminated. there's a caveat to that. Parental rights can't be terminated if reasonable services have not been provided throughout the life of the case. I mean, think about it this way. A parent needs help getting referrals and resources and services identified for them to help them reunify. And if they aren't given the appropriate resources or referrals or services, how in the world would they ever be able to reunify with their child? And how then why should they be penalized with the termination of parental rights if services were not reasonable throughout the life of the case? So this becomes very, very important that the agency has the burden to show that services were offered or provided. How this plays out might be, as service providers, you might be have a client who only comes to 1 or 2 sessions or doesn't come at all, and a social worker is asking you, can you please provide the documentation to show that the parent did or did not come to their sessions, to show that we've provided them the service, but then they didn't participate or partake in it. Then the meat and potatoes of all these review hearings is, have the parents participated regularly in their treatment programs, and have they made substantial progress? And as service providers with term, this is where you come in, because you, in dealing with that specific service, are really helping to answer that question. What is their treatment and what is their progress in treatment? Have they participated regularly? Are they making substantial progress? And then depending on the court hearing and the age of the child, the significant question is, if they're not going to have their child returned to them at that hearing, is there a substantial probability that the child will be returned by the next review hearing, by that next date, whether it's 6 months out or 4 months out? And then finally, if they're not making progress, if they're not regularly participating, should reunification services be terminated? Now that at a 6-month hearing can happen for a child under 3 or a sibling set placed together, or at a 12-month hearing for any child. But in order to get extended services to the 18-month date or the 24-month date, they have to show that there is a substantial probability of return. For a 24-month, which is 2 years of reunification, is only in limited circumstances where a parent was either doing some sort of inpatient substance abuse or is incarcerated for a portion of that time and is making really great efforts towards reunification. So this phase, again, these review hearings sometimes are set for trial. So you'll have multiple 6-month review hearings, it seems like, because they are continued or set for trial. But they progress through the 6, 12, 18, and 24 months. And at any time, depending on the facts of the case or the age of the children, services could be terminated and then a permanency hearing is set. Or at any time during these review hearings, they can turn into what we call family maintenance reviews, meaning the child is to return to the family, and then the family is given services to maintain them together under a family maintenance plan. And those can be set out another 6 months to ensure that the family's doing what they need to be doing, the child is safe, and then hopefully ending with the termination of jurisdiction at the end of those. So we can go to the next slide. Babby, I am on time today. This is like phenomenal. This is not usually happening either. So on, on the last phase that we're going to talk about just generally is that permanency phase. I should have put up here family maintenance reviews, because that's also permanency. The reunification with the family in a family maintenance status and then setting family maintenance reviews for 6 months at a time is also permanency. But if services have been terminated, then ultimately the question becomes, what should the permanent plan be? And so what we see is we have a 366.26 hearing. Sometimes it's called the 26 hearing. And the big question at that hearing is, what should the permanent plan be for this child? The preference from the legislature is adoption, and then guardianship, and then another planned permanent living arrangement. The preference is that adoption is the most permanent plan at that point, and then legal guardianship, and then another planned permanent living arrangement, in that order. So it's important to know that, because if the child is adoptable and there's someone willing to adopt this child, that's the preferred plan. And then we go through lots of different trials and elements and issues about whether the parent has a significant relationship with a child, or maybe siblings are bonded with one another to be an exception to adoption. But the preference is, if the child is adoptable, and or there's someone willing to adopt that child, that's the permanent plan. Legal guardianship is a permanent plan where parental rights are not terminated, but the child is under the legal guardianship of their caregiver, and has special benefits, receives assistance, and that legal guardianship lasts up until the age of 18 when that child reaches adulthood. But again, there could be visitation with the biological parents, and parental rights are not terminated under a legal guardianship. Another planned permanent living arrangement is a lot of letters that used to be referred to long-term foster care. So these are the kiddos who parents have not been able to reunify with them and are in long-term foster care or in APLA, another planned permanent living arrangement. Might be in a foster home, they might be in a group home, they might be at San Pasquale, they might be somewhere where they are in foster care. But they do not have another permanent plan at their disposal. And then every 6 months, their permanent plan is then reviewed under post-permanency planning reviews. When parental rights have been terminated and a child is set for adoption, there's only post-permanency planning reviews until that adoption is finalized. Legal guardianships, for the most part, jurisdiction is terminated and we get out of their lives. Sometimes there might be left open for 6 months or so just to ensure everything is okay. But in APLA, those kids' cases are reviewed every 6 months to ensure that the agency and the service providers and the supports are providing everything for that child. And first and foremost, question for those kiddos, it should be every day, but every 6 months is there another permanent plan that could be better for this child? Are there relatives out there who are willing to become a legal guardian? Is there possibly an adoptive home out there for this child or sibling set? Can we get to a better permanent plan than just APLA? So those are the hearings that are sprinkled in the rest of all of our other hearings through the timeline. This part of the timeline, this phase 4 for APLA, for let's say a child could go through reunification maybe in 12 months, 15, 18 months, something like that, but they might be in APLA for 10 years. So this is the majority of their dependency case for some youth. Or for others, this is only a hot minute when we terminate jurisdiction with a legal guardianship. So depending on the types of kiddos and the cases, this is like the meat and potatoes for many, many kiddos. So if you have kiddos on your caseload, they might be in APLA. And then we'll go to the last slide so I can, and timely. I know you guys are going to talk about this a little bit more throughout the morning, but just as a reminder that all of our juvenile court records, all of the agency records are protected under what's called Welfare and Institutions Code Section 827, that they are confidential court records and confidential agency records. So it's a big long section in the code, but only certain folks are able to review those records, whether it's the court records or the agency records. And if you are one of the exceptions to review those records, then that's great, you can do that. Otherwise, you have to petition the court to see or have copies of either court records or agency records as it pertains to a dependent child, as it pertains to a referral or an investigation, or anything within that pertains to a specific child in child welfare. As we go further through, and I'm sure Babby and the rest will talk about how you as service providers are able to exchange information and records because of the designations in 827 and our standing court orders that allow folks to do that. So, but in general, confidentiality is super important for the best interests of the child, to ensure that things that are private remain private. So I kind of just leave off with that because I think there's a big and broader, bigger discussion about confidentiality that's going to come up.
Thank you so much, Caitlin. All right, any quick questions?
See, that was a lot of information.
It was. No, and it was perfect timing. Thank you.
Okay.
Okay, so we're going to move on to our next presenter. Geraldine Bordage is a policy analyst. She has been with the county for almost 21 years. She's worked in several programs, including emergency response, voluntary services, continuing services, the Child Abuse Hotline, Plinsky Children's Center, and several others. She's currently in her 3rd year as a policy analyst and recently took over overseeing mental health related projects for child welfare. So thank you, Geraldine, and I will hand it over to you. And just let me know when you want to change slides.
Okay, sounds good. Thank you, Dr. Ravi. Good morning, everybody. Thank you for having me here today. So let's go ahead and get started. If you could go on to the next slide, Dr. Ravi. Okay, so before we go into the overview for child welfare services, I wanted to spend just a few minutes to ground the information that I'm going to be providing you today on the vision and priorities of child welfare services. And we call this our Safety in Hands Together, or SET. So SET is the practice framework for child welfare services. This is essentially how we want child welfare social work to look like in our county. SET is how we want to do business as an agency, how we want to work with our children and the families that we have, our stakeholders and our community partners. So for San Diego Child Welfare Services, SET supports our vision that every child in San Diego County should grow up safe and nurtured. And we know that children are more likely to thrive when they're part of a family. Next slide. So with that vision in mind, that vision that every child grows up safe and nurtured, we've identified 3 priorities to focus on. And I think Caitlin touched a little bit on this as part of our presentation, but our first priority is to ensure that children stay home when it's safe. And that's about 80% of the referrals that we receive when a social goes out and there's really no additional intervention happening in this family. And if that's not possible for the children to stay safe for their family of origin and they have to be brought into care, our second priority is to make sure that they can reunify as soon as it's safe, right? And that's about 60% of children within our work, they reunify with their family of origin within 3 years. And then if reunification is not possible, the third priority is to ensure that they have permanency, and not just in the legal sense that Caitlin touched on in terms of adoption and guardianship and APLA, but we're really looking at that lifelong connection with people who are important to them. Next slide. So our SET framework is, again, how child welfare services translate our vision and priorities. If we want kids to grow up safe and nurtured, if we want kids to stay home or reunify or have permanency, how do we do that? So we do that by practicing these 6 core values in our work. Value 1 is basically just having that understanding that having that good relationship with children and families, it's very important. And that is really the foundation of our work. That is what we do every day. That's what we try to do every day. Value 2 is partnering with relative caregivers and resource families. Resource families refers to our foster and adoptive parents. So that was something that, a terminology that was changed in just the last few years. So now we refer to them as resource families. Our value 3 is helping children achieve permanency. So again, not just in that legal sense, but also to really help children develop those lifelong relationships with people who care about them and will be there for them unconditionally. Value 4 is having that shared responsibility with community partners, meaning that they too share in our vision for safety, permanence, and well-being. And then value 5 is having that strong working relationship with the legal system and making sure that we're partnering with the courts, with the attorneys, with our CASAs and our law enforcement agencies across the county. And then value 6 just really looks at how we want internally, right, as an agency, how we want to have a workplace culture that values the well-being of staff and having leadership that builds engagement and that shared accountability. Next slide. So at any kind of presentation that I do related to child welfare services or mental health policies or anything like that, I like to spend those few minutes just to talk about the set values, because that practice can really influence a family's journey when they become involved in child welfare services. So when we have an agency, social workers and our leadership, when we keep those core values in mind, we can help a family heal. And for those involved in child welfare services long-term, we hope that keeping these values in mind and practicing these values every day can help them have that overall outcome, no matter how long they're involved with us, whether it's for 30 days or until they're 18 years old and age out of the system, or maybe even longer, right? If they're receiving services in extended foster care. So this slide here is just kind of a quick overview of the stages that a family may go through when they're involved in child welfare services. So I'll break this down a little bit further in the next few slides, but one thing just to be aware of for this slide, especially, just regardless of the case status or where the family is at with their journey, that we have practice elements going on here, which includes there's case management going on, there's permanency planning going on, there's also placement elements going on, as well as services occurring at during these stages that I'm going to be talking about. So next slide, Dr. Ravi. Okay, so the first stage, take a sip of water here. So the first stage I wanted to talk about is the child abuse hotline. So this is where a family can become involved, for the first time with child welfare services. The general public or mandated reporters can make a report of child abuse or neglect about a child in the community. So the hotline social worker, essentially, they're tasked with determining a couple things. They're tasked to determine if the call meets criteria for assignment, and if so, how soon would they recommend for a social worker to go out and respond? So that can be anywhere from an immediate response, which is anywhere from 2 to 24 hours. It could be 5 working days or 10 calendar days as response. And if the call doesn't meet criteria, then the report is screened out, and then that ends the family's involvement with child welfare services at that point. So just a couple stats, actually just one. I think a lot of people are always asking how many calls a month does the hotline receive? And it's been about, on average, it's up to about 4,500 calls per month. School personnel is our #1 mandated reporters. They are the primary callers. So if y'all can imagine, because we've had kids not being in school for the last year because of the pandemic, it definitely impacted that call volume when we had that stay-at-home order around this time last year. Next slide. All right, so once a referral leaves the hotline and it's assigned for investigation, it goes to emergency response. And then a social worker in that ER unit will go out and conduct an interview with the household members and collaterals, including calling back the reporting party to clarify, make sure that everything that was reported made sense and make sure it was correct. So at the end of that investigation, the social worker will conclude that allegation based on the information they obtained, right? So based on their interviews, based on information that they obtained from the child, the family, and any collateral contacts that were made. So some of that possible conclusion for the referral is unfounded, meaning that the investigation was determined to be false. It was maybe an accidental injury, or it did not constitute child abuse or neglect. The report could also be found inconclusive, which means that there's insufficient evidence to determine whether child abuse or neglect has occurred. And it could also be substantiated, which means that the investigator or the ER social worker found that there was child abuse that, as defined, right, that it did occur in this during this incident. So depending on the situation, the referral can be closed. And again, that ends the family's contact with child welfare services at this stage. But if during the investigation, the social worker deemed that there were circumstances where the child was immediately, like right at that moment, right? There's that exigency where the child is, that the child is unsafe right at that moment, then the child can be removed at that time. Otherwise, if there is no exigency, then that means that the social worker will have to file a warrant in order to remove the child from the home. Next slide. So if the ER social worker assesses that there's a need for further intervention, it can go two different ways. The first is that the family can be offered to participate in voluntary services if they meet criteria. Typically, in most voluntary cases, children remain in the home. The family has about 6 months for services, and that can be extended for up to 12 months if needed. And there are times when voluntary cases can also become court involved if there's ongoing concerns for safety that hasn't been addressed during the time that they have that voluntary case opened. And the second option for the emergency response social worker is to recommend court intervention. So I think Caitlin talked a little bit about this earlier with the family maintenance and family reunification. So when court intervention is recommended at this stage, the referral now turns into a case and it moves from emergency response to the court intervention unit or the CI unit. So the CI social worker is responsible for filing the detention report and then the jurisdictional and dispositional reports. And those reports outline reasons why child welfare services needs to be involved long-term, maybe what services would be helpful for this family, what the visitation plan looks like, and then what is the goal to ensure that the child is safe right now and long-term. So in court intervention, this is where a case plan is established, and the case plan, again, just outlines those safety goals, what services will be, that children and the parents will be participating in for the next 6 months, and what that visitation plan looks like, especially if the children are removed from the home, making sure that they have that visitation plan in place in that case plan. So after, next slide. Thank you. So after the court establishes jurisdiction, the case then moves from court intervention to continuing services. So again, in continuing services, social workers carry those family reunification and family maintenance cases. So this is where social workers conduct monthly visits with everyone that's involved in the case plan. They conduct those regular contacts with the collaterals, like that includes our service providers, to assess how the family is doing. So in child welfare services, we do have several specialty programs that carry a continuing caseload. So I just want to just touch on that just a little bit. So we have residential services, which is a program that we have that serves youth with behavioral health needs who are placed in a higher level of care. And that could be a foster family agency home, or it could be an STRTP. It's a short-term residential treatment program that's previously referred to as group homes, licensed group homes. We also have the Indian Specialty Unit in our North County office, and the ISU provides that case management in conjunction with tribal services to families who have been identified as American Indian. We also have a medically fragile unit that carries continuing services cases, and they serve youth who have been identified as medically fragile, developmentally delayed, or have a chronic condition that may require ongoing medical treatments or procedures and things like that. And then we also have a dual jurisdiction unit, and this is where we have youth who are ordered to be served by both child welfare services and probation, and they're called our dual status youth. And I think that's it. So a lot of our specialty units, just as a quick side note, they do carry those continuing cases, but they also, because they are specialized, they can also take on some of that emergency response role. They can go out and do the investigation if we have children who are identified as medically fragile, or if they are considered one of our ICWA, or the I'm drawing a blank on ICWA, Indian Child Welfare Act, meaning that they've been identified as American Indian. So when a family is involved in continuing services and children are reunified with their parents, or they've remained safe in the home for a span of time, and maybe the caregivers or the parents, they've met that safety goal, they've demonstrated those actions of protection, those cases can be closed. And that is another way that a family's involvement with child welfare services can end at this stage, at the continuing services stage. Next slide. Now, if the opposite happens, and that maybe the child can't return safely to the home, then the social worker will recommend for services to be terminated, and they can ask the court to set that hearing to determine the permanent plan for the child. So again, just referring you back to 3, and making sure that we have people, right, in the life of the child who will be there for them no matter what. So when children can't reunify with their family of origin, a permanent plan can be adoption, and that's the most permanent plan. This is where parental rights are terminated. And then the other one is guardianship, which is jurisdiction is terminated at this point, but the parents do retain their rights. If they want to file a petition later on to gain custody of their children, that's something that they can do. And then we also have that fit and willing relative, which falls under APLA. That is that long-term placement with a relative. And that's something that can be considered for permanency if adoption and guardianship are not possible. So with a fit and willing relative, this is where dependency is continued. We also have our extended foster care program, which is, this is where youth can continue to receive case management services from the ages of 18 to 21. And the focus at this time is to help ensure that they have those independent living skills needed as they move through adulthood. Next slide. Okay, so that was just the quick overview of child welfare services. So the next couple slides, where I'm going to talk a little bit about the role of the social worker in child welfare services. So these are just a few of their responsibilities. In general, social workers primarily assess for safety and risk in all programs and stages of child welfare services. So they build, they build those relationships with the child, the family, and their network to help conduct those balanced and rigorous assessments. So social workers help develop the safety plans or case plans that include the voice of the family and the child. They participate in the child and family team meetings, and that helps them collaborate with the family and the support network to make sure that shared decisions are made at important stages of the case. And of course, they also, as part of their role, they also make sure that there's ongoing communication with service providers to see how the family is progressing with their case plan. Next slide. So for children that are out of the home, again, going back to that case plan, the social worker makes sure that there's a visitation plan in the case plan for the family that is clearly outlined, right? So who is allowed to visit, how often do they need to visit, maybe what kind of behaviors we're looking for to be demonstrated during those visits, so that we're clear on what this visitation should look like. And then in monthly contact visits with the family, with the children and family, they're also assessing what kind of progress the family is making towards the safety goals. So if the family is going to 3 different services, what are they learning? How are they demonstrating that with their children? Things like that. So those would be some of the things that they're assessing when they go out for their monthly visits. And as I've mentioned before, they're also assessing permanency throughout the life of the case. So permanency we don't wait until the very end to assess permanency, right? So because permanency is important and it is part of our core value, we try to assess permanency from the very beginning. So we have, our hotline social workers, even though they're not permanency workers, they are not case carrying social workers, they do try to also assess for permanency when possible. So even just asking the reporting party if there's anyone else that cares about the family, or who has the family's back if they have an emergency, even identifying those people, that can be very important. That could be very important information for the emergency response social worker and for the continuing services social worker to have, because we can assess those who are identified and see if they can provide that ongoing support for that child, if possible. And then the other task is just making sure as a social worker, as the case manager, right, that they're clarifying those expectations for the families that they serve, for our service providers. They're there to answer questions and also provide referrals and resources as needed. Next slide. All right, so when we have children and parents who are receiving mental health services, the social worker will be collaborating with the term provider. So that collaboration can include regular dialogue and just kind of talking about how the treatment is going, and if there's new updates to the case that the social worker needs to share with the provider, that can happen again just as a dialogue. And then the other way that they communicate with each other is, of course, those written reports. So those treatment plan updates and reports that the term provider would be providing to the social worker, that kind of outlines basically how the parent is, or the child or the parent is progressing towards their treatment goal. Next slide. Okay, so it's important for social workers to be in regular contact with service providers, because this helps them, right, with that ongoing safety and risk assessment that they conduct every time they go out to see the child, every time they go out to check in with the families. And having these regular dialogues or having these reports from our providers, it really helps the social workers determine how to move forward with the case, right? So hopefully the information that's being provided can kind of help that social workers determine, are the parents doing the work needed in their services? Are they taking what they learn from their services and they're demonstrating those behaviors that keep the child safe, or work towards keeping the child safe long term, right? So so having that regular contact, having that collaboration, having that partnership, not just with our term providers, not just with our mental health providers, but really all service providers that are involved with the family. We hope that collaboration is ongoing, on a regular basis. So one thing just in terms of the child and family team meeting is, if we do have mental health providers identified for the child and the family, mental health providers are required members of the child and family team meeting. So hopefully that they can join that meeting so that they can, we can ask them how things are going for the parents, if there's anything they're worried about, things that are working well. And then help the team basically make that shared decision in terms of how to move forward with a case or case plan and things like that. So when we have mental health providers attend the child and family team meeting, they can be compensated for their time for participating in that meeting. Next slide. Okay, so I think this is our last slide for this one. I wanted to just kind of take a little bit of time to talk about our staff psychologist role. So to help social workers navigate mental health related services for children and families, they do work closely with our staff psychologists who provide oversight and support when assessing what maybe initial and ongoing mental health services our children and parents may need. So our staff psychologists provide, they make sure that our mental health services, that they are appropriate and available for what the need is for that family, right? That they're individualized to that child and to that parent. So our staff psychologists really play a pivotal role in making sure that you know, they serve as that liaison between child welfare services and our mental health providers. They also provide consultation in severe abuse cases and in cases where maybe we have a child or a parent that's presenting with serious mental illness. Being a case carrying social worker can be a very challenging job, right? So a lot of times they're exposed to trauma daily based on, you know, some of these referrals that they go out on, or the ongoing cases that that they go out on. So it can really take a heavy toll on them. So as part of our set values, we talked about value 6. You know, we also care about social worker well-being, and they're the ones out there who continue to do the hard work every day. I mean, especially just thinking about the added challenge of the pandemic in the last year, right? So we're very thankful to have access to our staff psychologists because, you know, they have been instrumental in helping social workers get that ongoing support and education about secondary and vicarious trauma. You know, so they've been there to provide that support so that we can also, as an agency, take care of our own. I think that is it for me. Yep. Last one.
Thank you, Geraldine. Any questions for Geraldine before we move on? Berta, I see you're here. That's great. Okay, so any questions? Okay, so let me introduce Berta. Berta Zangari is an attorney who has been representing parents in juvenile dependency cases for the past 20 years. She is currently one of the firm directors at Dependency Legal Services of San Diego, which currently holds the contract for court-appointed representation of parents in the juvenile court. She is a strong advocate of treating parents in juvenile dependency cases fairly and with respect. So with that, Berta, I will hand it over to you, and just let me know when you want me to go on to the next slide.
You're muted.
Can you, there we go. We don't have sound. Berta, we don't have sound. You're unmuted, but we don't have sound.
Can you hear me now?
Yes, now we can. Thank you.
That was a moment of panic. Okay. I'm Berta Zangari. I'm director of one of the firms here in San Diego. My firm has about 800 cases and 5 attorneys. Can you go ahead to the next slide? And there are 5 firms. 2 are the same as 2, mine and one other have about 800 clients. And then the other 3 firms are made up of 1 attorney each. I wanted this to be in the PowerPoint so that if you're wondering who you're working with and who their supervisor is, you might be able to get some information in looking at this directory. Next slide. So as parents' attorney, we really have several roles we fulfill for the client. We are obligated to advocate on their behalf in court, and that's the part everybody sees and is most familiar with. But we also advise the client outside of court. We advise them as to what goals are possible, the likelihood of achieving their goals, and what they have to do in order to achieve their desired goals. That's a little tougher sometimes. We're also the often bearer of bad news. You're not getting your kids back today. Yes, I'm the only one in the system technically assigned on your side, and I'm telling you, you're not getting your kids today. So it's a difficult role. We do need a lot of information to be able to back our positions up and inform the clients. But we also then hear what the client says. We're there to listen to every idea the client has and every concern they have, and then present what the court needs to hear about their concerns about the children and the system. Next slide. Next slide. Okay. So one of the things I was saying is we need a lot of information in order to do our jobs. First, to advocate for our client, we need to know when they're doing well and what we can present to the court in regard to whether or not they're doing well. We also need information to be able to tell them why they're not succeeding. If they are not getting their kids back at this moment, and that is their goal, they need to know why. And in order to discuss intelligently with them why they're not achieving their goals, I have to know a little bit about why they're not succeeding in maybe therapy or a domestic violence class or substance abuse treatment. I need to know the background and what's behind that. And in order to do that, I have to talk to service providers. At the outset of every case, our clients sign releases for us so that we can talk to service providers. We are happy to fax those releases over and want to be able to communicate. So if I don't know about what they're doing in services, I can't advise them. I can't advise the client about things I'm not hearing about. So if I contact a therapist or other provider and I'm met with a wall of silence, there's very little I can do in my job. And it is very difficult and very frustrating. If I got a call back and a fax number, I'm happy to send over the release, as is every attorney in DLS. We're more than willing to work with the therapist on what releases we need because our clients are adults and able to give releases. We just need to get that information. Next slide. I wanted to talk a little bit about some of the ABA standards that apply to Parents Council and how those touch on how we interact with therapists. We are required to do an independent and thorough investigation at every stage of the proceedings. So the fact that the therapist, the DV provider, and the substance abuse counselor all spoke to the social worker is not in and itself enough. The fact we can get what the social worker says you said from the report is not enough. We actually have a legal obligation, an ethical obligation to call you and say, this is what the social worker says you said. Can you verify or deny that's what you said? We're not doing it to be difficult. We're not doing it to be, repetitive. It really is part of our obligation. And if the client has perceived a difference in how they're doing in services from what the social worker has perceived, it kind of doubles our ethical obligation to make that call and to find out. We have to obtain necessary documents and make sure that they're shared, and that includes information from providers. When we cannot get information through an informal process by simply calling and asking and speaking to someone, we are required to use formal methods of discovery. This includes the subpoena. We often want to go through informal processes. I think it makes everyone more comfortable. But sometimes to get documents and information, if we're hitting a wall, we legally and ethically have to subpoena information that we need. We are also obligated to engage in case planning activities on behalf of our client. We do try to attend CFTs when the client wants us there. We try to use a multidisciplinary approach to making sure the client's needs are being met. So in regard to parents getting the services they need, we really want to know if for some reason they're not succeeding and they need something else to succeed. If you are their therapist and you feel that they need a psychological evaluation or they need an additional aspect to their case plan, a parenting class, they're not in the right substance abuse treatment. As parents counsel, that is something we really need to know and advocate for. Next slide. I did want to talk a little bit about, we do need to sometimes subpoena for testimony. So even though you have told the social worker your opinion and your thoughts, and you have told the attorney your opinion and your thoughts, the judge needs to hear from you directly. It is an important part of the process, and judges really, really take into consideration what a therapist or another professional has to say about the case, the client's progress, whether or not they're learning, and whether or not they pose a current risk to their child. Those are all factors the judge really wants to hear as much detail as possible regarding services and service providers. Now, some therapists and other providers have said to me, "You don't want me there. It will hurt your client." That is my responsibility and my ethical obligation to figure out that. Because your statements may hurt the client's ability to get their child back in the moment, I still may feel a need to subpoena you because your testimony may be what is necessary to get them additional time and services to get their child back, or to convince the judge to order the additional service that they need in order to be successful. So while overall your testimony might not get the client the desired result they want, it may in fact get them one step closer to getting what they need to get that result in the future. And that strategy call is up to the attorney assigned to the case. And so if you feel your testimony may hurt the client, please respond to the attorney. Let them know why. Let them make that call as to what the strategy is and the goals are and how that information factors in. Occasionally, it seems that when therapists feel it will hurt the client, they then dodge the attorney, leading to us trying to make decisions at the very last minute on what's best and how to proceed. It is best, if you think your testimony is going to be harmful, to share it with their attorney and let them make the strategy calls. That's the best thing for the parent, and it allows everybody to kind of factor it in advance rather than spending a few weeks chasing the therapist and getting to the eve of trial trying to make decisions on what's the best strategy. So dodging subpoenas and refusing to speak to parents' attorneys until the last minute really helps no one. It doesn't help the parent, it doesn't help the attorney, it doesn't help the court make good decisions. And it comes down to, it also doesn't help the therapist or provider, because we are willing to work on timing of testimony, what time of the day works best for you, what day works best, those sorts of things. And pre-pandemic, it was a bigger issue, but now everybody gets to testify via video. But we can work with you on timing, but since we can't make those decisions unilaterally, we have to have other attorneys weigh in, and we have to have the court if it's a timing issue, but other attorneys if we just want to submit documentation. That can't be done at the last minute. So the earlier we talk, the earlier we address it, the sooner or the better result we'll have on working with you in regard to submitting a letter or working on the timing of your testimony. Next slide. Okay, I want to talk a little bit about testimony. The service provider is not supposed to be the parent's advocate on the stand. They're there to help in testimony to inform the judge as to how well the parent is progressing in the given service that provider is providing. It is important to truthfully answer the question that you're asked. And again, answer the question asked. If it seems like the answer is negative, that's okay. The attorney for the parent will bring up the positive information that helps the strategy of the case. There's going to be negative information. Don't spend time on the stand trying to dodge the answers that come out negative. It's all balanced together, and it's understood that no parent in the system, no person, quite frankly, is perfect. We expect some negative information. So don't worry about being an advocate on the stand. Don't offer opinions beyond your expertise and knowledge. Don't swear that based on your knowledge that this person will never use again, because of course that's not credible. Don't swear that you know this person will never make, they could never make that mistake again. They're unlikely. They've done a lot of work. They've made a lot of progress. Don't overstate. Don't go beyond your expertise and what you've been working with the client on. And understand that the cases are, I want you to also to understand that the cases are part of a court process, and that the client, the parent you are seeing, has the right to the information being presented. The judge will eventually decide whether or not they get to continue having a relationship with their child. And if they don't get to have that continued relationship with their child, they have every right to know what that decision was based on. So those letters that you write to the social worker get submitted to the court considers them, and the parent knows about them. I'm going to share one story where I did have a therapist write a letter to the court and hand it to the parent. Said glowing things. They wrote another letter to a social worker who attached it to a report, and it said a bunch of negative things. Hopefully that never happens again. Really undermined the therapist's credibility, but I think they were trying to build rapport and be on the side of the client and work with them. But in the end, they lost all credibility with the court, all credibility with the client. There's just no getting around. The client is going to, if you have concerns about the client is going to hear them. Either from you, from their attorney, or when the judge is quoting it from a social worker report to them on why they'll never see their kid again. So it's important, it's easier and it's better, and they're able to address it the sooner those concerns and thoughts are shared with them. Next slide. So when I was talking about delay and about not getting back in touch with the attorney and sharing information, but also that if you think the client needs something else, if you're working with them in domestic violence treatment and you really think they need substance abuse treatment based on some things you've seen, or you really feel you cannot put your finger on why they're not succeeding, you need to start recommending to other people, get it out there that the parent needs a psych eval or needs these other services, because a parent may be limited to as little as 6 months. If at the 6-month review, what happens is everybody starts talking to the therapist for the first time, and the therapist says, oh no, they've not made any progress because I have this concern about them, and I think they should have been in substance abuse treatment, domestic violence treatment, or they really need a psych eval and we need another 6 months. They may not have another 6 months. If the child is less than 3 years old, they may not have more than 6 months to make progress. If they make progress, they can get more time. The maximum time frame for most cases is 18 months. There are a few cases where we can stretch it to 24, but generally the maximum is 18 months. And given that short time frame, it becomes crucial that the exchange of information is happening. Not just that the provider is sharing what concerns, if progress isn't being made, we'd like to hear from the provider as soon as possible. But if you feel like you're not hearing anything back from the social worker about the case, you're not hearing anything from the agency, you might have a person in front of you who appears to be making wonderful progress and their visits aren't progressing. Their communication just becomes incredibly important. And when you start getting calls from Parents Council looking for information, again, keep the timelines in mind as to there is a significant limit on how well a parent can do, and there's a significant limit on how much time they have to make that progress. And without communication, we may not get there. Next slide. I just want to really briefly, I know I've got 1 minute, want to briefly touch on one of my concerns as Parents Council is as a therapist or other provider, you're required to treat the petition as true. You're required to treat the petition that is found true as true. Please make sure that you have the petition that was found true, not the original one filed. If the client is telling you, if the parent is telling you, no, that petition was not found true, and you say, no, I've been told there's a true finding in the case. It may be it is possible to have a true finding on something different than the original petition. The agency, the social worker, should be able to provide you with the actual petition that was found true, and that is the one you're required to accept as true by the court. Same goes for the case plan, and also keep in mind that there are reports generated frequently that will provide new information, and I find that therapists only seem to get the first 2 reports and the first petition. So make sure that if you feel you don't understand what's happening in the case or while working with your client, please ask for new reports from the agency. I think I'm out of time.
Thank you so much, Berta. That was wonderful. We appreciate that so much. All right, any quick questions for Berta before we move on? Okay, we have one more presentation before the break. I'd like to present Steve Weedle. He is the managing attorney for Firm 3 for Children's Legal Services. And I'll hand it over to you now, Steve.
Thank you, Babby, and good morning, everyone. I want to first thank all the presenters thus far. They've been terrific presentations, so thank you for that, and thank you for Babby for having me here today. So what I want to do today is talk very briefly about the general role of minors counsel, and then really focus in on our subject, confidentiality and the therapist privilege. So let's start with the first slide there. So how do we get appointed? Very explicitly in the Welfare and Institutions Code, section 317, the court must appoint an attorney for each dependent child, unless it finds that the child would not benefit from having an attorney. So there's very, very few scenarios where the child will not benefit from having an attorney. In fact, there's really only one where attorneys from CLS will decline to be appointed and look to this particular section, and that's where the child's whereabouts are unknown. You know, in order to be an effective advocate, in order for the child to benefit from our advocacy, we have to be able to talk to them. You know, if they're verbal, get their wishes, what do they want to do? And even if they're nonverbal, we need to be able to lay eyes on them, assess the situation in order to advocate properly for them and for the situation. But really the prime directive of the children's lawyer is to advocate for the protection, the safety, the physical well-being, and the emotional well-being of the child. Basically, their best interest. That's what we're here for, to look after their best interests. Next slide, please. So that same section, 317, also imposes on us the obligation to investigate. You know, that means interviewing witnesses, interviewing relatives if need be, interviewing people at school if the school is involved. You know, and I want to make it clear, we're not social workers. They have a skill set that we do not possess, and frankly, we couldn't do our work without them, as well as you, all the service providers. But we do a lot of their investigation based on what our clients tell us, and then we're obligated to follow up on that. And that allows us to make recommendations to the court regarding the child's welfare. Again, their best interests always being first. And we always represent the child's wishes unless they contradict the child's safety. And let me talk about that a little bit. In addition to being appointed attorney, we're also appointed guardian ad litem. Now, you might have heard the phrase guardian ad litem before. In the more general sense, in the general population, that's someone who can basically take over all aspects of a person's life, medical, finances, etc. We are what's called a CAPTA, GAL. That stands for Child Abuse Prevention Treatment Act. It's a federal law. And in order for states to get money through this law, they have to appoint GALs for the minors. Now, we essentially wear two hats, an attorney hat and a GAL hat. The attorney hat is what we tell the court what our client wants. Our client says, I want to go home to mom. The court is going to find that out because that's our job, to make sure that the court knows what the wishes are. However, if that contradicts what we think is in the best interest of our client, we have to let the court know that as well. An example would be, I have a 10-year-old client. She is in court because of sexual abuse by her mother's boyfriend. We're a couple months in the case. She tells me she desperately wants to go home to mother. She misses her. She loves her. The social worker's report says that, well, things look pretty good. Meanwhile, I've had an investigator go out to mom's house, and my investigator has seen the boyfriend around the house, has seen his car, has seen him enter the house. That's a problem. So at court, of course, I'm going to let the judge know that my client loves her mom. She wants nothing more than to go home. As GAL, I can't agree with that due to an investigation. The court will look at that, and the court will make the decision. But they do take GAL role of attorneys very seriously. And even if we can't reveal, because of confidentiality, why we can't agree, they will take our words under consideration. So we have two hats. And as the client gets older, 16, 17 years old, the GAL hat gets really, really small because they're almost an adult at that point. And we're going to advocate for anything they want. Conversely, for an infant, a toddler, our GAL hat is very big because they can't really tell us their wishes. So that's just touching on the GAL attorney hats. How about the next slide? And of course, this is why we're here for the main part of the presentation. The same section, 317F, instructs that the Minors Council holds the privilege, the therapy privilege, until the minor is of sufficient age and maturity. So of course, that begs the question, what is sufficient age and maturity? It's such an attorney phrase right there and so ambiguous, but the section does instruct us on that as well. And we'll see in the next slide there, Debbie. So in most cases, it says this explicitly as an example in the section, a child 12 and over is considered of sufficient age and maturity, unless it's, can be rebutted. And an example of that would be a child with special needs, someone who's developmentally delayed, who doesn't quite understand what the release of information and confidentiality is. But once a child turns 12 and we don't have those factors, that child is in control of the release of their therapeutic information, even over the objections of their attorney. So I might consult with my client who's 14, who's not ready to go to CFT, and we know some confidential information is going to be discussed. I might talk to them about that and say, do you really want this to be known? They might agree, and I might talk about the options, the consequences. But in the end, if they say, yeah, I think it's important that people know this, they get the final say. Next slide. So these are some of the things that we hear as attorneys when we call the therapist, the term therapist, to get some information. And these are some of the misconceptions we want to clear up with this presentation today. One thing we hear is, I really can't talk to you without the social worker's okay. This is incorrect. Now, the social worker does make the referral to the term provider, but after that, the privilege is ours. In other words, the only permission you need to talk to me is me. I'm the child's attorney. Another one is, I need mom to sign the release before we can talk. Again, once a petition is filed, that privilege that the parents might hold goes out the door and it shifts over to me. So once again, you don't need the permission of a parent to talk to the child's attorney about the therapy. Another one is, I can't even confirm if I'm the child's therapist. Actually, you can. And it's basically for the same reason. Once a petition is filed and I ascertain to you that I am the child's attorney, you, of course, can confirm to me that you are the child's therapist. That's a rare one. We rarely get that one. A common one, though, is I'm not allowed to share details or actual quotes from the therapy of the child with you. Again, you can, since we hold the privilege. The court is looking at us to make sure that our clients' needs are being met in every aspect of the case, from school to therapy. In order to assess that, we need to talk frankly with the therapist and have the therapist talk frankly with us how things are going, how the youth is reacting, what they're saying. Again, this is all confidential information, but it can go to us since we hold the privilege. Next slide, please. With records, pretty much the same thing. There's a section in the penal code that allows records to be obtained by the representative of the child, and that code includes therapists. So we, in fact, can look at the records. Now, having said that, we, of course, cannot look at the records of a parent's therapist. We don't hold the privilege for that at all, and that would be totally inappropriate. But as a child's therapist, we, of course, can look at records regarding and relevant to the therapy. Next question. I'm sorry, not question, slide. Thank you. So this is the big question. What about treatment reports prepared for social workers? The case law is pretty settled here. The social worker and the court is entitled to basic information. They have to have that information in order to make the best decisions forward for the child, especially the judge. He or she needs to have that information so they can tell how the child is doing. How is the child benefiting from therapy? What more could be done if need be? So the next slide, we'll talk about what we can share in those reports. So what's okay to share in a treatment report? Obviously, participation. Is the child participating? The dates of attendance. And beyond just participating, is the youth engaged? Are they actually engaged in the therapy? Because that's the only way it's going to work. I think we all know that here. You can share the goals of the therapy, and along with the goals of the therapy, the diagnosis. You can also talk about the progress in those goals. We're making really good progress here. In this last week, we had a really great session, and in that aspect of our treatment, it's going really well. This aspect, this other goal, not so well. That's the kind of things you can share. What's not okay to share is the confidential communications. Example, a direct quote from the child. Just can't do that. While you can share that with me as the holder of the privilege, that can't be shared with either the social worker, the judge, or frankly, anyone else. Also, you can't talk about the details of the therapy or the advice, the therapeutic advice you're giving the youth. That also is confidential. And that would be something you could share with the minor's counsel, but not in a basic treatment report to the social worker. And then also, this is one people might not think of, but conversations from treatment that occurred before a dependency proceeding began, that also can't be shared. And I think that's triggered by the petition filing. Oftentimes there is therapy going on in a voluntary case, but that can't be shared in a treatment report. Next slide, please, Betty. So I want to talk about CFTs because term therapists are involved in a lot of CFTs, and CFTs can be a little complicated because you have all kinds of people involved in them. It's just not the parties of the case, social worker, attorneys, parents, youth. It could be relatives. It could be a probation officer. It could be a service provider who's not a therapist. So the current concerns makes us nervous. I like the word concerns better. We're always concerned during a CFT that a child hears more than he or she should. Specifically, I'm talking about when CFTs are really frank affairs and pros and cons are discussed about the parents. And sometimes it's not good, the well-being for the child to hear bad things discussed about the parents. So we're a little concerned about that. We don't want to create false hopes. Reunification is just around the corner. Don't ever want to say that. We're also concerned sometimes the child being scared or maybe uncomfortable of a participant in the room. We also don't want the child overwhelmed with all the information that can come in a CFT. Now, that's more likely to happen with a younger child who just basically can't understand everything that's going on than an older child. But of course, an older child can be overwhelmed as well. And then our biggest concern, of course, is people getting access to confidential information who should not be getting that access. So here's some things you can do prior to a CFT and during a CFT. One thing that's a great thing to do is talk to the facilitator beforehand and let them know that if these topics come up relating to therapy, it would probably be best if a child step out. And that would be to protect the child from hearing something bad about a parent or maybe not so good about a parent. Here's another thing you can do, which is before the CFT, role play with the child and talk about what he or she wants to share. You know, what is it that you want your parents to know? Or what does he want the social worker to know? Is there something that you don't want your Uncle Fred to know? Talk about those kind of things. Also talk to the child about who they want in the room with them. You know, there might be supports that even the social worker doesn't know about. There might be a neighbor down the street that the youth spends every afternoon with, helping out in the yard, for example, and has become really close to that person. Social workers don't know everything. So if you get that kind of information, reach out to the social worker. And if you hear that the attorney might be a support, reach out to us. You know, it's been great in the last couple of years. We've been able to go to CFTs on a regular basis. And I get really positive feedback from the social workers with our presence. We're not there to talk law. We're not there to discuss anything legal. We're there purely for support for our clients, and also there to pitch in and say what's going well with the parents. But the bottom line is, before CFT, if you have any questions, just communicate with the lawyer and discuss what could be revealed and what cannot be revealed because of confidentiality. Now, again, if the child is 12 and older, he or she gets to decide what's discussed. And it might be over my objection, but it's up to him. He or she holds the privilege at that point. Next slide, please. So if either I or the actual minor signs the CFT, release of information for the CFT, what can you talk about? It's pretty much in line with what we talked about before. You're allowed to talk with the parties, again, not non-parties, but the parties: social worker, parents, child, CASA. If a parent's investigator is there, they're entitled to hear this as well. And it's that basic information we talked about before: participation, engagement, progress, those kind of things. You can't share confidential information with any non-party, even if, for example, the uncle. So let's go on to the next slide. So psyche evals, who gets the psyche evals? I'll kind of pick it up here. I got a lot of information in a short amount of time. The attorneys get the psyche eval. The court and the judge, of course, get the psyche eval. Social worker, probation officer, CASA are entitled to the psyche eval. No, people who don't get it without a court order, mom, dad, even the youth, and anyone involved in the school. They have to go through a process where there is a process, but it involves a court order. Next slide. Uh-oh, testifying. Everyone's afraid of testifying. Next slide. And I get it. I've had to testify before. It's a little nerve-wracking. So these are the types of testimony we're probably going to encounter: live, in-person testimony, testimony over the phone, if everyone agrees, written letter in lieu of testimony. That's often a really common way to get testimony in from a therapist. And then stipulated testimony. Very simple. Attorneys come up with questions, send them ahead of time. The therapist answers them. If everyone agrees, it goes into court, into the record, without having to be there in person. I guess it should be a number 5, MS Teams testimony. Next slide. And what does it mean to testify? It's pretty straightforward. You want to give your resume so everyone knows your qualifications. The person who asked you there, the attorney, is going to ask you questions. All the other attorneys get to ask follow-up questions. A big thing we get is, oh my gosh, I don't have my case memorized. I don't know everything about the case. Bring your notes, bring your therapy notes. If during testimony you get a question that you can't remember, you're allowed to look at your notes and refresh your recollection, is what it's called. You can't read from your notes, but you can take a look at them. Oh yeah, now I remember, and then testify. Next slide, please. And will you be forced to reveal, confidential information? Well, here's an attorney answer for you. Maybe. So our job as minors counsel is to anticipate when confidential information might be coming out. If we hear a question asked that we know is going to lead to confidential information, at that point, we're probably going to ask the judge to pause. I'm going to consult with my client, if I haven't already consulted before the hearing, to find out whether they're willing to allow that information to be released. If not, I'm going to assert privilege. And then the judge will decide whether or not that information comes out. Next slide. I think that's it. Oh, 1 minute over, not bad. So that's kind of that's a lot of information. I know we want to go on a break right now, but what I thought I would do is I put my email in the chat box. If you have any questions, just shoot them to me. Thanks, Babby.
Thank you so much. That was wonderful. All right, any quick questions before we go on break? Okay, so we will return at 10:30. If you just want to stop your video until then, I will see you in about 13 minutes. Thanks, everybody.
Really quickly, for those of you that have not taken the pretest, I'm going to go ahead and put it in the chat for participants.
Hi, Bobby.
Hi, Kristen. How are you? Nice to see you.
Nice to see you. It's been a while.
It's been a while. I'm so glad you're here, though.
Thanks for having me. Just wanted to let you know I'm ready whenever you are.
Okay. We are we're videotaping, so I'm hoping that because there's so much good information being presented here, I'm hoping that people really are able to view this as a video who weren't able to be here. So,
Perfect.
yeah, we'll wait a little bit yet.
And then you're doing the slides.
Yeah, all you have to do is tell me next slide, please.
Okay, perfect. Thank you.
Okay, we're getting ready to start again. Anna, are we good to go?
Yes.
Okay, excellent. All right, so welcome back, everybody. I hope you had a good break. So now I would like to introduce Kristen Balelo. She has been with Voices for Children for the past 8 years. In her current role as Director of Advocacy, she manages the traditional court-appointed special advocates, or CASAs, program overseeing 30 staff and more than 700 CASAs. Prior to Voices for Children, Kristen worked as a minors attorney in Los Angeles County. Thank you for being here, Kristen, and I will turn this over to you now.
Thank you for having me. We're pleased to be here. If you could go to the next slide, please. So if you don't know much about the CASA program, I just want to explain a little bit about our role. Sometimes we get confused with a mentoring program, but first and foremost, we are an advocacy program. So while we want CASAs to have a relationship with their case child, so I guess even if I take a step back, CASAs are assigned to either one child that's in the foster care system or a sibling group of children. And their role is to be an extra advocate for them. We hope that they have a relationship, they can go on outings together, you know, build their relationship. But first and foremost, the CASA is an advocate, and the CASA's role is to see if there are any concerns or important issues slipping through the cracks, such as there might be school issues or therapeutic needs that might not be being addressed. So they will contact the social worker and the minors attorney to make sure that those items get addressed. So while we hope that there is that fun aspect, taking the children out, experiencing new things, first and foremost, they are advocates. Next slide, please. CASAs are volunteers, and a CASA typically has one case. Once in a while, our rockstar CASAs take on multiple cases. They may have two, but they really have the opportunity and the time to focus on a child or a sibling group, whereas you all have high caseloads, you know, you're spread thin. So CASAs can be a really good resource for social workers and attorneys and the judges, just kind of being that an extra set of eyes. Next slide, please. CASAs are information gatherers, not information givers. So a CASA will communicate with everyone in the child's world and then report back to the judge. So CASAs will communicate with family members, teachers, parents, all of the attorneys, therapists, doctors, their placement, group home staff, and then report back to the judge. Unfortunately, CASAs are not able to give information to anyone but a select few people. We'll get to that in a second. So if you were to encounter a CASA and you were asking them questions, they wouldn't be able to provide the answers, but could probably point you in the right direction. Next slide, please. The CASAs, CASAs go through a great deal of screening. They have 3 interviews with staff at Voices for Children. They have over 30 hours of training. We also have requirements of continuing training as they are on their CASA journey. They get live scanned for the Department of Justice, the FBI, and the Child Abuse Central Index. Because CASAs can drive children, we get their DMV report annually, and we get updated auto insurance annually. So they go through a pretty strenuous vetting process. Next slide, please. They also, at the time of their graduation, they will take an oath of confidentiality, and we always invite one of our juvenile court judges to come to our graduation, and the CASAs will raise their hand and swear that they will protect the confidentiality of the case and their case child, which is why they are information gatherers and not givers. And we take that at Voices for Children, we take that very seriously. Next slide, please. As their therapist, the CASA should provide you with their appointment letter, and it will look like what's on the screen there. On that appointment letter are two important things that I want to point out. The two circles in red would be their supervisor's name and their supervisor's phone number. So every CASA is assigned to an advocacy supervisor who is a staff member at Voices and who is their resource and person that guides them throughout the case. If you ever had any questions or concerns, you can always reach out to their advocacy supervisor to answer any questions you might have. The box below, I know it's, sorry, the box below is kind of hard to read, but that's our grievance policy. And that explains the process if you ever had a complaint about a CASA or about any staff member at Voices for Children. You could follow that process and we will address your concern. Next slide, please. Also attached with that appointment letter is the CASA court order. And we're going to go through a couple of these. It's kind of reiterating what Steve just talked about the confidentiality and patient therapist privilege. But CASAs are ordered by court order. CASAs do have access to almost all of the child's records and files. So they are entitled to look at the social worker's files. They're also entitled to look at the court file. And that's based on, making that oath of confidentiality, and they are considered officers of the court. So they are held to a pretty high standard. Okay, next slide, please. The next section talks about the therapeutic patient privilege. So the CASA can look at any medical records. However, nothing that would violate the therapist patient privilege. So like Steve said, confidential communications, anything that's discussed in therapy. I'm going to reiterate in a few minutes a lot of what Stephen said. Next slide, please. And this is who the court order mandates who a CASA can disclose information to. So the CASA can only disclose information to the minor's attorney, the social worker, the assigned probation officer, and the court. Unless the court specifically authorizes a CASA to disclose information to someone else. But that I don't think I've ever really seen that happen unless a CASA testifies in court. So those are the only people that the CASA can give information to. Next slide, please. So like Steve said, the therapist patient privilege is held by the child's attorney. But what if a CASA does get assigned to one of your patients, and this is children only, CASAs typically never ever have the right to know or will not contact a parent's attorney. I'm sorry, a parent's therapist. That would have to be by explicit permission from the parent's attorney. So that this would only be in the case of a child's therapist. So what can be disclosed to the CASA are the goals that the child is pursuing in therapy, their attendance, are they showing up? Participation, are they showing up, but are they talking? Are they actually actively engaged, or are they not actively engaged? And then the progress on their goals. Next slide, please. Okay. We also have a staff advocate program, and those advocates are called case liaisons. And I should add, we also have senior advocacy liaisons who manage CASAs as well as have their own staff advocate cases. They are also appointed by the court. They will monitor cases that aren't quite a CASA level case, but could be. And so we can assign a CASA on those cases immediately if anything changes. Next slide. And just, Babby had asked to address some of the COVID challenges that we faced. One of the biggest challenges has been that we have not allowed in-person visitation for most of the last year. And that's been difficult in new CASAs that are coming on. Like, how do you establish a relationship with your child if you can't see them in person? So that's been something that's challenging in building those relationships, having those fun outings. We've just moved into a new phase where in-person visits have been allowed for a little while. And now we were allowing CASAs to transport children under many parameters, masks, kids have to sit in the back seat, and everyone would have to be amenable to that. The caregiver would have to be in agreement, the CASA and the child, and even the social worker. So if anyone was not amenable to having a visit, we are not forcing visits at this point. So that's all I have. I think we have a couple minutes if anyone has any questions. Thank you for your attention and your time.
Thank you so much, Kristen. Any questions for Kristen? Okay, and Steve, if you would check the chat when we come back after, I think, the next couple presentations, maybe we can answer the question in the chat.
Yeah, I can't answer it in the chat, but very happy to answer it in person over MS Teams as well.
Okay, excellent. All right. I'm on. All right. So as I mentioned in the beginning, I'm Babby Weingarten, and so I'm in charge of our behavioral health program at Child Welfare Services. We have 3 senior clinical psychologists who help run this program. And we work incredibly hard trying to come together to help our social workers and our parents and our kids really get the right services for their cases. So I'd like to start by kind of filling in my input on the role of term therapists with child welfare cases. I honestly believe that you guys are the heart of what we do. So the courts and child welfare, we sort of set the stage for that transformation and healing to happen. But it's really you're the vessel through much of what that transformation and healing happens. We have revamped our policies quite a bit in the past few years, including increasing the number of referrals for individual therapy and for the types of evaluations for both our children and our parents. So our parents can receive individual therapy through term if it is on the case plan, it's on the court-ordered case plan and directly relevant to parenting. They also can receive therapy through behavioral health services, through many of our community clinics. And a lot of our parents, as you know, have histories of trauma, and having that individual therapist on the side, besides all of the other types of things that we are having them do for us on the case plan, whether it's child abuse group or sexual abuse group or IPV group, having that individual therapist on the side to sort of really help you through navigating all of this, I just think can be so important. So that's your role as the individual therapist. You're critical. You're a critical piece of this. Our children we're probably referring almost 90% of our kiddos to therapy at this point. And some of them get referred to term therapists, some of them get referred to community clinics. Just sort of depends on what the referral is for. But we have the CANS now, the Child and Adolescent Needs and Strengths assessment. And, you know, you just have to have some stress for our kiddos, and just being involved with child welfare can do that. So the majority of our kids are getting some type of treatment, and I'm really pleased about that as well. We also made changes to our evaluations. We have always done psychological evaluations. We have added full psychiatric evaluations and neuropsychological evaluations as an option. The psychiatric evaluation is not the typical medication evaluation. We have parents with severe mental illness, and sometimes we just need a psychiatrist to step in and render judgments and give us some answers to questions that we have about potential risk factors. So those psychiatric evaluations have been coming in incredibly helpful. And the neuropsychological evaluations, we have parents with history of head injury or children with history of head injury. And the neuropsychological evaluations can really help us know, you know, cognitively, can the parent participate in treatment? And even more importantly, are there compensatory mechanisms that would help them benefit from therapy or benefit from our process more? So our job is always to try to figure out, how do we do the best for our parents? So if you're an individual therapist and you really think an evaluation would help, let us know, let the social worker know, because that the evaluations can really drive treatment. And trust me, when we look at those psychological evaluations or any of our evaluations, the first thing we do is look at, well, diagnoses, but then we look at all the answers and the recommendations for treatment, and we follow them. We have to follow them. So you're really, really important. Okay. Basically, what we want is for you to understand, engage, and treat our families, and to really understand historical trauma, to know a bit about epigenetics, because it's so important, to know about culture and how trauma-informed care can help families heal. And I just listed some of our evidence-informed treatment that we have approved and that Optum will adhere to. So, of course, your job is to increase adaptive coping skills and reduce learned ways of coping that don't serve our youth or our parents. And that's what we're counting on you for. And to follow the treatment goals of the case. So, as mentioned before, make sure that you do know what the protective issue is, what the true finding is, and what is on the case plan for the parent or the kiddo. And then communicate with the PSW on progress. So I just want to end with, you know, I talked about how our senior clinical psychologists work on secondary traumatic stress with our staff. And I just think it's really important for you as therapists to take good care of yourselves too, and to monitor your own secondary traumatic stress. Because we're all sort of leaders in the field of trauma work, right? Especially if you're working with child welfare cases. So just recognize your importance in helping keep children safe and families together. And remember your passion for your work. I always talk about, the business world talks about knowing your why. And I think it's really important in child welfare when you're doing work with our families and our kids to sort of have that mission and passion in mind. Because we see so much and we hear so much. So here's just a couple of things on how to keep growing in resiliency, because we can do that. We can continue to grow in resiliency. We're not necessarily born with it. Practice mindfulness, practice wellness, and seek out professional support and consultation and therapy when you need it. These are my contact and Geraldine, our mental health policy analyst, and I will put the contacts for the other two senior clinical psychologists in the chat. All right. Okay, any questions for me before we go on to our next presentation? Okay, so I'd like to introduce Lorena Avatea. She's a licensed clinical social worker and registered play therapist in private practice. She has been working in the field of child and family trauma for almost 20 years. With the recognition that trauma's effects live in the body, yes, we know that, Lorena recently became a registered yoga instructor and has been incorporating both mindful movement and mindfulness into her practice. And with that, I will hand it over to you, Lorena.
Thank you. Good morning. Can you hear me? Wonderful, wonderful. Thank you so much. What I want to do with the wonderful information that you gave us right now, Dr. Weingarten, why don't we go ahead and just kind of collect ourselves? We're going to collectively take 3 mindful breaths. I think we just need a little bit of a break to just reset our minds right now. So what I like to do when I'm doing this, I'm with the clients or with myself, is I like to sit up straight. Our back is erect, but it's not stiff. And I like to actually roll my shoulders up and back and then just let them melt down. And now we just kind of open our heart center. And what I'm going to have you do with these 3 mindful breaths is just focus on that natural pause that happens between each inhale and exhale. Okay, so let's go ahead and do that. We're going to inhale. Exhale. Inhale. Exhale. And one more inhale. And exhale. And welcome back. I actually like to use that in between each client, especially now that I'm sitting in the computer in front of me with back-to-back clients. It just allows me to just, just put everything away that happened with my previous client and just renew myself a little bit. So it's just something really quick that you can use yourself or you can offer your clients as well, and even make it very playful with children. So with that said, what I'm going to be doing today is I'm going to be providing a very quick overview of the clinical framework for term providers. I am a term provider, and I know that Blanca, Erica, and Belen are going to be providing more information, but I will go ahead and just review some of this. Next slide, please. And my apologies, Babby, because I realized that I thought I was going to have access to that. So you're going to have to click on that until we get that. So first of all, just some things to keep in mind as term providers is that the treatment that we provide with our clients is forensic in nature. This basically means that we have to be objective and impartial when we're providing these services. This has to be reflected in our documentation, and always keep in mind that as term providers, our opinions matter in terms of decisions that are being made for the reunification with children. So being impartial and objective is really important. We also, as discussed earlier, are expected to accept those allegations as facts of the case. So the true findings have already been determined, and we have to actually provide the services through that lens. And confidentiality, we know, and we talked about that already. This differs from our typical psychotherapy with other clients. Confidentiality is limited because this information, certain information is shared with other providers, with a CFT staff, with the CWS staff, with the court. So please just make sure that you follow everything that was discussed earlier, recognizing who holds privilege to the information, recognizing that we need to obtain releases of information from the Minors Council, and also obtaining the child's assent is additionally recommended when appropriate, because we want to be able to give children and youth the ability to have a sense of control and power over something that has been so powerless in their lives. Next slide, please. So just continuing with the treatment, there is an extra set of obligations associated with the treatment that we provide because of the fact that we're providing services that are rendered in behalf of the requesting agency, which is CWS at this time. So compared to other psychotherapy services that we provide as clinicians, the treatment goals that are specific for CWS cases are going to be more directly to the effects of the abuse and the neglect with children and toddlers and, of course, youth. And for parents, it's going to be focused on the protective factor. Of course, keeping safety in mind, but this is a little different, and this is kind of where your lens is going to move you forward with. We are also required to use methods and interventions that are within the bounds of our professional competence. So really keeping that in mind. And then the last part that I want to mention regarding just general treatment for CWS cases is that optimal clinical outcomes result when we provide both trauma-informed services and also evidence-based practices. I have actually provided here a few resources that you can actually access that are really just something that are great to have. The first one there, the California Evidence-Based Clearinghouse for Child Welfare, actually rates practices based on the evidence. And then also it rates the practices based on the relevance with child welfare. So if you're interested in knowing a little bit more about some treatment that you hear about, a service, a program that you hear about, and you want to know, well, what's the evidence behind it? And then also, what is the relevance to child welfare? It's a really great resource to have. And then the other one that I want to mention is the National Child Traumatic Stress Network. If you don't know about this resource, if you don't use this resource, as term providers, I highly encourage you to have that in mind. There are fact sheets for providers, for parents, for teachers, for the court. There's trainings, and everything is free because it is government funded. So you can get a lot of free information there that you can even use for yourself. It also has information on evidence-based practices that are specifically for children and youth that have experienced trauma. Next slide, please. So some considerations for term treatment. These are going to be just more general here. And hold on just a second. So the first thing, as we talked about earlier, is just consult with your social worker often throughout the case. Changes happen. Transitions happen. And this is the best way to be able to just keep the focus on how to support your client, your child, the parent, and be aware of any changes that are happening that are going to impact your treatment. I've definitely, social workers are very, very busy, and I have had several cases where changes have happened, like reunification, and I'm not informed, and that's really important to stay on top of that, and that way you can actually plan ahead of time and support your parent and the client as well. And the best practice here is to seek professional consultation. We know that professional consultation can help with compassion fatigue. We know that it could help with countertransference. It could help you with ethical dilemmas. There's just so many benefits to having consultation. And if you are able to identify a consultation group or a consultant ahead of time, it can really help you in those moments that you feel that there's something that's going on right now that I really need to consult with somebody. And, the anxiety kicks in. It's really good to have something already prepared and ahead of time that you can consult with here. Also, just as a reminder, just make sure that you obtain all required documentation from the social worker before your intake. All of that documentation, as discussed earlier, is going to have a wealth of information that can help you with your case conceptualization. It can help you guide questions, specific questions that you might have for your referral. It's also going to have the releases information, consent to treats in there. So just make sure that you have that information before your intake session. And something with telehealth, I know this is new for all of us providing services through term in the last year, but with telehealth services, it's really important that we abide by our legal and ethical obligations. Make sure that you have, you protect your client's health information, that you have a BAA with every service that you're using, a business associate agreement, whether it's your video conferencing that you're using program, whether it's your emails, whether it's your fax. We want to make sure that we protect the client's privacy. And also some developmental considerations regarding telehealth. Just pay attention to accessibility for these clients. Do they have appropriate technology that you're not going to be breaking off too much? Do they have privacy where they're in home? Are you able to, of course, know where they're at, their location in case of an emergency? And then the other part that I want to add is that developmentally appropriate considerations, especially with younger children. I do have to admit that as a play therapist, and I've been a play therapist for many years, working with younger children using telehealth has been probably the most challenging. And if we remember that play is basically the language and the toys are their words, what kind of toys do these children have at home that you can use for therapy? And this is something that is going to come to play even more now that hopefully we're going to be able to see our clients face to face, and we might have the opportunity to continue to provide telehealth services. But if you do, keep that in mind. Who would really benefit from telehealth services and who would really benefit from in-person services as well? Next slide, please. So as term providers, some considerations for term treatment for the parents. We talked about earlier that the protective issue and the risk factors are the focus of therapy. So basically any other interpersonal issues become secondary unless they actually really directly impact the protective issue. So these interpersonal issues might be something related to their self-esteem, their self-confidence, perhaps important decisions that they have to make. If they're not related to the protective issue, it's definitely something that's secondary within the scope of our practice as term providers. There is a stronger emphasis on the challenging of those distortions related to the abuse, whether there is minimization, denial, inappropriate guilt, or blame. We really need to work through those so we can actually make some changes in their cognitions. And also we need to make sure that we are very careful not to over-align with the social worker or the parent. That goes back to that, for instance, the services that are forensic in nature, that we are here to provide objectivity and impartiality. And also for term parents, keep in mind that this is the opportunity to provide a psychoeducation, the opportunity to provide trauma-informed parenting skills. Just to mention a little bit about the trauma-informed parenting skills, I've had opportunities with working with many parents, even after or during reunification, where they've shared that they've received amazing, really great skills, but some of them have not necessarily been trauma-informed. We parent children differently when it's trauma. And so going back to the website, the NCTSN, the National Child Traumatic Stress Network, they have an amazing resource that as term therapists you could use. It's called the Caring for Children Who Have Experienced Trauma. It's the resource parent curriculum. This is the same curriculum that is used for the TIPS program here in San Diego, the trauma-informed parenting services, and it's a pre-service for foster parents, resource parents. So you can actually download that for free. I've had the opportunity to train that curriculum across the United States, but I use it personally in my practice to provide psychoeducation. There's exercises that you can use to improve the understanding of skills. And it's just a really great resource for you to have and for you to be able to share with your clients and your parents. And the last here is to create and implement an individualized self-care plan. We know how important that is. We know how important that is, not only during the time that they are receiving services through child welfare, but also afterwards, because difficult things happen in life. And we want to make sure that they have that support, and then they have also some personal strengths and resiliency that they can actually reach out to. So next slide, please. Now, a little bit on the framework for parents when it comes to the treatment. So during the intake basics here, so just some intake basics, we talk about obtaining release of information. They are the holders of the privilege. So this is a really great time to be able to understand who's working with the parent. They might be involved in domestic violence classes, child abuse classes. They might be receiving psychiatric services. Having a conversation with a social worker, right? So having that would be really important to just keep in mind and obtaining it from the beginning. Also explain your role as a therapist, as a term therapist, and how that's different from traditional psychotherapy. This is really important because that can help you build that trust from the beginning. We don't want parents to be confused about what our role is. We don't want parents to feel that we've deceived them in some way. So establishing that from the beginning is really important. Explaining that as a term therapist, you accept those true findings that we talked about earlier and how that might impact your relationship. Really important, again, establishing that trust with the parent. And also explain that the therapeutic goals are guided by both the protective issues and clinical need. And this is, just especially for a lot of parents that have been in therapy before, and for them to understand what the focus is. And this can actually guide you in the future and help you whenever other issues might come up, and how you can just kind of bring them back to what's the protective issue here. The psychosocial rapport, or the trust building phase, just something quick to remember. Of course, always obtain that the extensive history, all the way from the beginning of early childhood to the present, and identifying the trauma, stressors, identifying strengths, of course, intergenerational patterns, a lot of psychoeducation that can be used, and a lot of resiliency that can be built there, because that's what they want to be able to create for their children. Stop that kind of pattern. Immigration experiences, a lot of trauma, a lot of shame around that. So it's important to get that information. Discrimination experience, especially now, a lot of people might be either triggered, or a lot of individuals might be willing to talk about that. This might also guide you in terms of how they see the system, if they've actually have had any negative experience with the system in the past. And so there's just a whole list of important information here. The attachments, because an attachment style can help you understand how they relate with others. So this is really important to gather. And this is the time to focus on support and validation of their own experience. Next slide, please. So just to continue on this, it's going to be really important, and it was touched upon earlier, that we want to be able to have the opportunity to review the protective issue with the parent. Use your clinical judgment. You will understand how much the information the parent is willing to hear in terms of details. But at the beginning, it's really important that the parent understands what the protective issue is, why they're there, and it's only fair for them to have that information. Also, just keep in mind that many parents might have not understood what the protective issue was. They might have been extremely anxious, and they don't remember that information. There's so much information that they're given at the beginning of a case. Or also their own trauma history might be not allowing them to remember those important information. So it's really important to review the true findings in the protective issue. During this time, also make notes of the client's statements regarding protective issues and the true findings, but as discussed earlier, do not put those quotes in your reports. This is just for your own progress notes. Identifying denial, level of cooperation, resistance, readiness to move forward with reunification. Of course, not at the beginning, but it's just kind of gives you a little bit of, where are they at right now? And something to guide you for future work with the parent. We also want to just make sure that we are, when you're reviewing the protective issue, there's definitely a way that we can be remembering to be empathetic and to be compassionate, because this might be really difficult for them to hear. Treatment goal development, we also, of course, if it is related to the protective issue, we want to be able to include compliance with medication, a relapse prevention plan, identifying triggers and stressors, and anything that's going to help them with their psychosocial functioning. Next slide, please. And now some considerations for term treatment for children and youth. And of course, I could actually take time to separate these two, because it's very different how we would approach young children and youth. But, with time, we just kind of put them all together. But what we want to do with our children is we want to overall just promote that emotional healing, improve their psychosocial functioning. We want to increase their overall safety, both psychological safety and physical safety. Understand the protective issue. Children have the right, in a developmentally appropriate manner, to know, why is it that I'm not living with my parents? And, with early childhood, we want to be able to help support them with their social emotional development as well. And just kind of keeping in mind that the Minors Council is not only the child's advocate, but also the holder of the privilege. What we want to do as well, and I think this is really important, is to consider if, when, and how a caregiver or parent can be part or can be involved in some aspects of the child's therapy to support the child's developmental trajectory and healing. You know, of course, I always think about this situation with my own personal experience of how much can I provide to a child for 50 minutes a week, knowing that there could be caregivers that could be very supportive and helping them with any skills, that they're practicing the skills at home, how to respond to them when they're triggered. And I think it's just really important to be able to just assess if this is something that would be important, and encourage you to consider that, and also obtaining the appropriate releases to do that. In particular, if you're using TFCBT as a model, or you are, of course, using attachment-based therapy. Consulting with your social worker or any of the term staff clinicians around this would be very important as well. Next slide, please. So just kind of a little bit of guidance again regarding the framework for children and youth. And the intake basics here is that also just explaining your role as a term therapist, and as developmentally appropriate, your limits to confidentiality within your specific role. Again, it goes back to building that trust, in particular with this population where their sense of safety has been shattered, and trust is a big part of that. Remembering that there's a movement towards professionalizing a foster parent, which somebody had mentioned earlier. I forgot her name, but she named it perfectly. What we're trying to use, the words that we're using now, the term is resource parent. We are professionalizing their role. They can be a great resource. I highly encourage to work with them. You don't have to provide privileged information, but you can definitely provide, help, just kind of give them some skills to work with the children as well. And of course, if you need to, I would encourage you to get your release of information in place. Being mindful of what's shared to you in front of the child or the youth. I've seen this even when I worked in a previous agency where I know that space is limited, especially if we are in an agency in the waiting room, and sometimes we want to lower our voice, but just be really mindful because children are very hyper aware, and we want to also protect their privacy. So throughout treatment, during telehealth, be very mindful of what's being shared in front of you. And during this time, begin to assess for risks and proceed as indicated. And during the intake, we are starting to, with the parent, or the caregiver, we are completing the PSC, and the PSC needs to be completed as a reminder during the assessment phase at the beginning, during the treatment plan update, or every 6 months, whichever one comes first, and then also at the end of treatment termination. During the psychosocial and rapport trust building phase, we want to obtain as much developmental history as possible through all those reports, documents that we receive. Again, identifying as much information as needed, as we talked about with the parent. Completing the CANS, which also has the same deadlines or intervals as the PSC for the child. And then focusing really on support and validation of the child's experience. Next slide, please. And just really continued here, the goal development, heal from the abuse, learn to protect themselves. We talked about that. And I just want to keep in mind that the child might identify separation from the parents as a primary trauma, remembering that trauma is perceptual, and that has been my experience that many children, the separation has been extremely traumatic for them. And, keeping within your scope of competence, we're also expected to assess and treat other emotional behavioral health issues. Next slide, please. And if you want to know more about where I received all this information, this is the source. It has a lot of information and goes in depth regarding the points that I just made. Next slide, please. And thank you so much. I just want to remind all the term therapists out there that I am, it's an honor that I am your representative in the term advisory board meetings. So if you ever want any updates or you want to provide me any feedback, please feel free to reach out to me. That is my contact information there. And thank you so much.
Thank you so much, Lorena. Any quick questions for Lorena before we move on to our last presentation? Okay. Steve, are you staying till the end? We'll ask the question at the end. Are you good with that?
Yeah, I have to leave around 11:35 for a court call at 11:45.
Okay, let's do the question now. All right, the question is, there are many times that CFT meetings are scheduled just a few days within the time that therapists are informed. Should we, term therapists, obtain an ROI from minors counsel during the initial phase of therapy to prepare in advance?
It's a great question, and I feel your pain. Attorneys often get notice of CFTs the morning of, but I think therapists, to start off with, therapists have a bit more, use a better word, standing to ask to continue the CFT if they can attend, because they're so important to the CFTs. But to the question, it's an interesting question because I'm assuming the question is basically a CFT specific release of information. I think it's a good idea. And I want to bounce it off the other folks in the other firms and other managing attorneys. My one question that pops in my head is that as the case progresses, the issues of confidentiality might be more complex than early on in the case. And so it might be later on in the case, there might be more issues of confidentiality that need to be discussed between the therapist and the attorney, or the attorney and the client, before the release of information can be signed. So I think that would be the one hitch in doing basically a sort of a pre-signed CFT or a release of information. But that's a really great question and a great idea as well, because we all get hit by these CFTs sometimes very late, and you guys are really busy. It's hard for you to rearrange your schedules on such short notice. I do want to mention, I don't know if it's been mentioned yet, but we are working on sort of a one-page cheat sheet for release of information. I think we're really in the final stages of that. So I think we're going to have that done soon. Exactly, thumbs up on that. But that is a really good question. So what I want to do is I'll take back to my firm and get some input, and then maybe at the next term meeting, Babby, we can discuss it then.
I think that would be great.
Fantastic.
Yeah, and then we can do some information. All right, thank you so much, Steve. I appreciate it.
Problem.
Okay, so our final presentation, I'd like to introduce Erica Osuna, Blanca Lugo, and Belén Barragan. They are our term clinicians, and they will speak to their role in this process. Belén, you're muted.
All right.
There you go.
Thank you. TERM, or the Treatment and Evaluation Resource Management Team, is a quality improvement program mandated by the County Board of Supervisors. The next slide would be great. Thank you. Probation, CWS, and juvenile court use behavioral health information to make decisions, and they rely on TERM to ensure the quality and appropriateness of behavioral health services provided. There are different aspects to ensuring quality and appropriateness. One being the work done by our provider services department. Their focus is on contracting and credentialing of providers who have experience providing treatment to the CWS population, and our focus, or TERM's focus, which is on the quality review of work products. For the purpose of our presentation today, we'll be focused on the latter. Next slide, please. TERM work is considered forensic. There are laws in all states that require the provision of reasonable efforts to help families improve the conditions that brought them into CWS. These services are often court ordered. Cases are reviewed in court, and the information provided will be used in case decision making. Because of this legal context, therapy with CWS referred clients is not considered standard psychotherapy, as there is always a potential to be subpoenaed. Our TERM panel is a specialty panel. Providers are responsible to know which competencies are reflected in their provider profile and ensure to only accept cases that are indicated as a special competence on their profile. Next slide, please.
So as Babby and Lorena also pointed out, there's key differences between forensic treatment and standard psychotherapy. Basically, the PSW in this case is the case manager. So therapists are expected to work closely, like Lorena explained, with the PSW to follow the case plan. Any recommendations that a therapist might have, any additional services that they think would benefit the client's mental health, it would be important to communicate it to the social worker, as the PSW would be the person coordinating and doing the referrals. Obviously, the main focus of therapy is the safety threats and risk factors. For parents, they have short timelines that require treating just the direct causes of abuse and neglect, and the focus should be on decreasing the risk, increasing ability to safely parent, and provide just a general safe family environment for the kids. The therapist is to accept the true findings as well, and like Lorena explained, there are different ways to approach that in treatment. The therapist is to remain unbiased and objective as a friend of the quote versus the client advocate. And the therapist does not make ultimate decisions or offer ultimate issue opinions, and does not make any recommendations whatsoever about placement or visitation. It is also important to avoid multiple relationships with a family. So an evaluator cannot, provide an evaluation and also provide psychotherapy to the clients. And it is important not to see different members of the family, especially if you are the therapist for the parent. You should never be providing conjoint treatment or treating the child in any way, shape, or form. Next slide. You're muted, Erika.
I apologize. Appears I have to unmute myself in like 3 different places, but because every case has different needs with CWS, it's important for term providers to stay updated and utilize evidence-based practices that have the most research support and efficacy for the effectiveness of the treatment. It is the expectation that providers will follow the best practice guidelines and meet the ethical standards outlined in the professional groups in which they are affiliated. We do have some of the resources that can be used. These are just 2 of the ones that we often see, but it's the California Evidence-Based Clearinghouse for Child Welfare Services and the SAMHSA National Registry of Evidence-Based Practices. So always keeping in mind that the needs of the client should align with the evidence-based practice that is selected. The next slide.
As part of the term referral process, whether it's funding from Medi-Cal or CWS, some clinics even take grants or VOC, the process is the same. We ask the clients not be seen until the authorization letters, the therapy referral form, and case records have been received and reviewed. As such, authorization letters can be considered as a green light in the sense that upon receiving them, term has already conducted a thorough review of past treatment. We've considered the family members involved and the provider specialties. We also look to not have any cases designated as HVC be assigned to entrants given the complexity in the treatment. Next slide, please.
So as the quality assurance team, term has oversight of the CWS referrals. That means we do a high-level review of CWS referrals to make sure that they include all the clinical relevant information for the therapist who will be assigned to have, along with the authorization letters. We have oversight of individual treatment, psychotherapy treatment for parents and children. Oversight of conjoint psychotherapy treatment for children and parents. And for those cases where both parents are referred to conjoint psychotherapy to address how to co-parent safely. Also, we have oversight of probation and CWS psychological evaluations of domestic violence victim groups. And with those, we do annual site monitoring and quality assurance of group progress reports as well as we do for the individual therapy. We also have oversight of the child sexual abuse non-protecting, non-offending parents. We also do annual site monitoring and quality assurance of their progress reports. For the other groups, the child abuse groups, the sex offender treatment groups, and DV offender treatment groups, it will be probation who has oversight of the quality of those services. Next slide, please. So as part of our quality assurance of when we review the reports, obviously we have to ensure that therapists submit them. So the initial treatment plan is due 14 days post authorization date. The treatment plan updates are due every 12 weeks thereafter until the therapy has been terminated. And just as a courtesy service, Optum will be sending a letter the third Monday of every month, and that letter will include the treatment plans that are due. So when you receive the letter, make sure that if there's information that does not match with your records, that you give us a call and let us know so we can adjust the dates to make sure that we have the correct information, and the reminders are obviously useful for you. So the expectation for providers is to submit the treatment plan for all the clients listed on that letter. If treatment plans are not submitted within the required time frame and you have not contacted us to resolve the discrepancy, it could be elevated to a complaint. If it is CWS policy that therapists not write letters to PSWs as a way of communicating about the client, or letters to the court, the treatment plan should be utilized as the only form of written communication to PSW in court in general. Next slide, please.
So all treatment plans and evaluations are subject to be reviewed by an Optum term staff clinician. So just so you know, we do have 2 psychologists and 4 licensed clinicians who are able to review the treatment plans and determine whether they are meeting the specific needs of the quality review process. Providers are responsible for reviewing the term provider handbook for the treatment plan guidelines, and work products are reviewed against the term provider handbook and nationally recognized practices. Just so you know, you can also access our term provider handbooks, and it's often updated to meet the needs, and our treatment plan resources in our Optum website at www.optumsandiego.com. I can go ahead and share that website at the end as well. When questions or concerns arise, the term reviewer will contact the provider to discuss the specific issues that were identified, and the provider and the term clinician may agree that the provider will submit an update to the submitted work product in order to clarify any concerns. We do have certain expectations as to the communication and when the information is expected from the providers in order to meet, case timelines and case meetings, such as court and things like that. The next slide.
In reviewing any work product, quality issues include, but are definitely not limited to, reasonable services concerns, risk issues. We look to have that clinical thread or the internal consistency between the client's history, the presenting symptoms, the diagnosis, the treatment goals. We look for the documentation of progress to be supported with behavioral examples and not vague statements. Are the treatment plan and documented progress updates objectives and absent of bias? We ask that the provider remain within their scope of practice. We look to have goals that can be met by the specified techniques, that the cultural issues are considered and addressed. And of course, we look for completion and timeliness.
So the main step, or the first main step of our quality review process, is for us to read thoroughly the CWS referral form. And we are looking for the following considerations: for all the family members involved in the case, for any information about the client's diagnostic history, for the reasons why the family was involved with CWS, which will determine what the true finding is, or will inform what the true finding is, any description of mental health concerns identified by CWS, what would be the safety goals if the client has ever been prescribed medication, currently taking medication, compliant with medication, and which other agencies, professionals, or services the client is involved with. Next slide, please.
So the next few slides are going to be our treatment plan sample. We're just going to go briefly over it because I know we have some limited time and we want to be available for questions if there are any. But just so you know, there is an expectation that the provider will complete all the areas and update it as needed when we go through the treatment plan update and discharge. We do want the dates of attendance to be documented, as that often guides the expectation of progress or lack thereof, since that will definitely impact the treatment and the determination that CWS would make. Next slide. So as mentioned before, we really want to know that the records are being reviewed, and so that all considerations for this case are being incorporated in the treatment planning. One of the things that we look for is the risk assessment, and that being updated often in order to best reflect that the client is being assessed for safety. We want all risk factors to be captured there, so it doesn't just have to be suicidality and history of harming others, but also if the client is in danger for any kind of other form. It could be domestic violence, it could be exposure to physical abuse again, or anything like that. We also want the risk assessment to correlate within the whole treatment, and we want to make sure that there is a goal for any reason or any risk factor that has been identified. The next slide. So we want the goals to be measurable, of course, and we want the evidence-based practice interventions that are being utilized to have congruence with the interventions listed. So we want the goals and the interventions to match. With that, we also want the progress to look like it has behavioral examples. We don't want the client is doing good. We want why is the client doing good and what is the client doing really, because that's going to best reflect with the facts of what's going on. Next slide. So for the discharge summary, it's important that we let the PSW know, as Lorena mentioned in her presentation. We want to be in communication with the social worker at all times, especially if you are discharging the client for lack of attendance, or even if the case is just closed, so you have to discharge. It's important that we know that you have notified the social worker and that we know the date of discharge. Also, we want to make sure that if you say that the case is successful in meeting their goals, that the progress reflects that kind of success and that the behavioral examples are present in how those goals were met. We also want the client's signature to be present for adults. I know with telehealth, we've been a little bit more flexible and we take we discussed it with the client and unable to sign and things like that, but just keep in mind that we do want to consider this as the client's treatment plan and their agreeance to working on the goals that are listed. For the diagnosis, we want to make sure that we're using ICD-10 codes. So just make sure that you are documenting those and that for any diagnosis that you make, there's a goal that's addressing that specific diagnosis. We also can take B codes. I know that it's not often common because of insurance things that people don't use just B codes, but there are times when B codes are just the only thing that's listed. We often prefer that there is an assessment for any kind of diagnosis or mental health. And if you go to the next one. So feel free to rule out any diagnosis that you feel would best apply for the client. Diagnoses are often, historical diagnoses are often documented in the referral form, and we encourage for providers to document their assessment of those and to rule those out if there is any potential for rule out. Of course, the provider is always able to make the determination and to see if they meet criteria or not, but just to keep those in mind in the event that it is a need. And we also like to see that there is appropriate release of information if any documentation of communicating with other providers in the system of care for this client. We also look for the brief assessment. We want to make sure that the client's functioning awareness of own mental health concerns is documented and that we are always considering the strengths of the client as well as the obstacles. It's important that all aspects of the client's life are considered, and sometimes the obstacles can be transportation while they have all this desire to attend treatment. So we want to make sure that all of that is captured. And feel free to use the additional comments section for any specific additional thing that may not have a spot. We have providers who often document their communication with the PSW, and we often keep track of that in their treatment just to make sure that everything is congruent and following together. Then last but not least, don't forget to sign. We always want that signature there. Next slide. Yeah.
So the term complaint process, it's if quality problems are of sufficient concern, a complaint against a provider may be filed. We don't get that many complaints a year. Complaints can be submitted by any stakeholder in the system: PSW, probation officer, the judge, the attorney, the clients themselves, another provider, term staff, and of course, CWS staff psychologist. When a complaint is received, a member of the term team is designated to investigate and gather information regarding the complaint. So details of the complaint are always discussed with the provider. We have a very transparent process. We will be reaching out to the provider and informing the provider that, a complaint has been submitted, provide details, and just try to gather as much information as possible. And depending on the nature of the complaint, documentation, treatment records, progress notes may be requested. The complaints are always, the focus is to try to have term mediate those complaints. In the event that that's not possible, complaints are then reviewed and by a committee of licensed clinicians who determine any recommendations or actions of areas for improvement, which if it gets to a different level, then it might include elevating to credentialing committee as well. Next slide. So that would conclude our part of the presentation. Let us know if you have any questions.
Thank you so much. I appreciate that. Any quick questions for them or any general questions from anything that's been presented through the day? I did want to let you guys know that we uploaded resources into the chat. So there are a lot of resources that I think can be really helpful for a lot of what was discussed today. So any questions, any thoughts as we wind up? Okay, thank you, everybody. We appreciate your attendance and participation, and enjoy the rest of your day.
Thank you.
Thank you.
Thank you.
Bye.
It's great to see some